I want to thank everybody for being here today. This is the Public Safety Subcommittee of the Appropriations Committee. We're going to be talking primarily with the courts today, but we've got a few other agencies, and then we will hopefully complete the rest of our agencies on Monday beginning at 1 o'clock? 1 o'clock. And except for indigent defense, which we will hear from next Friday. So anyway, we've got some other committee members who said that they will be here, but may be stuck in traffic. So we will go ahead and start. And I think, Madam Chief Justice, if you will. If y'all tap that microphone, make sure I've got the right one.
Now it's on. I think you are well aware of the problems in the Supreme Court.
How about pull that mic a little bit closer to you, please, ma'am? Thank you.
After the state of the judiciary, I think it is clear the budget cuts and the current problems that we are having. Trying to cope with an increased caseload and a very, very short staff, in particular in the clerk's office. And I stated yesterday that we are the only Supreme Court in the nation that I know of that uses unpaid interns to man, basically, the front office and to help with docketing. I want to also take this opportunity to really praise our clerk and our deputy clerk. They have been working long hours in the evening and the weekends to do the business of the court because the clerk's office is so short-handed. One of the requests that we have made for enhancement was for a docket clerk position. It would be exceedingly helpful and absolutely necessary to fill that position. While the interns do their job and they do it well, you need someone who's going to be there for a long time and really be skilled in docketing. We have also asked for salary parity with the staff attorneys that work on the Court of Appeals. There is, with the highest paid attorneys, the comparison on the Court of Appeals, their staff attorney, the highest paid staff attorney, makes approximately $2,200 more a year than what the staff attorneys do on our court. We would like to have parity for our clerks as far as their pay is concerned. You will see that they also, the highest amount, I guess, in requested is for the Appellate Records Project. The court has put into place an e-filing system that seems to be working very, very well. And in response to 1055, we also devised a rule so that there could be filings by attorneys straight into the court, and that seems to have worked fairly well. This Appellate Records Project would basically allow the clerks of the various courts to send the record up directly to the Georgia Supreme Court. Now, this would be available also to the Court of Appeals, that we can replicate it there. I think in the long run it will result in savings, particularly in the clerk's office and in some respects in the Georgia Supreme Court. We used to have someone who manned the record room because what you're talking about is paper. With this particular project, that will not be necessary. Anyone can access the record from their own computer because all of those pleadings are open to any attorney or the general public.
Chief Justice, if I can interrupt for just a minute, for the members of the panel who are not attorneys, if you would just sort of maybe give a brief overview of the paper that you're talking about as far as the stuff that's filed, the stuff that has to be transmitted to the court, and how this may, in the long run, save money.
The record is transmitted, can be anywhere from, and it's all the filings that are in the clerk's office, both the state court and the superior court. And there can be instances where the record can be as much as 33,000 pages. We have a case that's coming up under our rule now with the appendix that the record is 33,000 pages. That record is required to be brought by the clerk or sent by the clerk to our office. It then has to be maintained in a satisfactory way. This new appellate records project, the clerk with the push of a button could send it. The information could be scanned as it's received in the clerk's office, or maybe even received in the clerk's office electronically, which would substantially reduce the personnel that would be required to prepare the record and to send it to the appellate courts, both the Court of Appeals and the Georgia Supreme Court. I think in the long run there would be an incredible savings, and there are clerks in the state of Georgia now who have that ability to basically send the entire record up with the push of a button, but unfortunately the appellate courts do not have the technology to receive it. So we are asking for that ability, and we have asked for it as an enhancement in the 2012 budget.
If I may ask a question at this point, as I understand it, your staff has been cut significantly during the current budget crisis, if you will. How much staff have y'all lost?
8. We've lost 8 positions.
Out of how many support staff?
We have 43 now, and so you're looking at 50, 51, 52 people. We were very efficient before. We did not have personnel that really wasn't needed. What we have done is to take the cuts through personnel loss, and we are in a position now where we cannot continue to do that. We have cut our budget through expenses and through personnel, and it has been very difficult. At the same time that our caseload is increasing, in particular death penalty cases are up 33%. A record was brought to me yesterday in 2 volumes, and that's going to have to, with the execution pending, that's going to have to be resolved by the court probably within the next 2 or 3 weeks. We have very complex litigation that goes on in our court, and we were efficient before, but we are down to the bone at this point in time. There are no more personnel that we can lose.
The interns that you have now, are they basically filling in for the 8 positions that you lost?
Oh, there's no way they could fill in for the 8 positions. They are filling in for positions in the clerk's office. They answer the phones, they receive filings, they do pre-docketing work, but we lost some staff attorneys during the budget cuts. So while they are necessary and they're doing a very, very good job, they do not and cannot fill the position of a docket clerk, and we do not know how long they will be there. They will, at least one of them will graduate this year and will be looking for a full-time job. It's wonderful that we have the opportunity to have these interns get course credit. I don't know that the clerk's office could continue to function if we did not have them.
Chairman Willard.
Madam Chief Justice, the people that you lost, the clerks, these are law clerks, ones who do the assistant of preparation of review of briefs, preparation of the decisions, opinions.
We lost one law clerk. We lost two people from the reporter's office. That actually comes down to, I guess, one person, because we share the staff with the Court of Appeals, and numerous positions in the clerk's office. That our clerk is working as hard as she is because someone has to get the work done because of the personnel that was lost.
Not to interject, Mr. Representative Willard, but we have now, we have the clerk, and we have 4 employees who are all docket clerks. So if you're talking about what we have in the Supreme Court of Georgia's clerk's office, you've got 5 full-time paid employees.
We know last year under 1055 we had the problem about the appellate costs on appeals of records being prepared, and your court stepped forward and helped find a solution for that. We've got a bill coming through this year. A couple of follow-up questions at that point. Does your court plan to continue that process, which has been allowing the attorneys to prepare the records and submit that to the court?
Yes, we do plan to continue that as an alternative,
right,
to having the clerk prepare the record.
In doing that, your experience this past year, has that added further burden to the court as far as getting records in and preparing them, reviewing them, etc.?
Yes, I don't think there's any question. It has increased the workload, both of the Supreme Court and certainly of the Court of Appeals. So, yes.
What has been your feedback from the bar members as far as that process? Has it been acceptable, a good alternative? Is that what you're feeling from them?
I think it has proven to be a good alternative. I would hope that the State Bar would hold some CLE programs on how to do it. Even though the information is there on the Internet, I think it would, on our website, and I believe on the Court of Appeals website, as to the process to use, I think it would be very helpful if there were instructional courses.
I think, Mr. Chairman, follow up on the 2 positions, or the amount, not positions, excuse me, the amounts. The $109,939, is that for hardware, as I call it, the machines that will be needed, for lack of a better term?
Let me check with the clerk. Oh,
it is.
Justice Melton.
What I'm looking at is the 2 figures. You got one being, I guess, the hardware, and another one, the $98,400. Is that for software, or is that something different?
That's exactly right. The 98 is for software. That's to create the portal to allow these big packages to travel from the trial court to the Supreme Court. The $108,000 is hardware, servers, to actually hold that information once we get it.
Are these based on what I call requests for proposals that the court's received, or how has it been determined, that amount?
In the e-filing system that we have right now, we used a vendor. That vendor quoted us these prices. We've also contacted 3 other vendors to get an idea from them what they thought the cost would be. What we heard back from them was, well, we really don't know, but one vendor specifically offered to study the project for about $30,000 to $40,000. So
one would not help without the other, my point. You have to
That's
have
correct.
both if it's going to be done.
That's correct. One is to make it get there. The other one is to enable us to have a place for it to land. And then the other software will help us actually manipulate, because once you get these large records, you have to be able to search through it. Imagine a lawyer sitting with a stack of paper. They would have Post-its. They would have table of contents, indexes. You can go to certain pages. And so we have to have those virtual capacities
One last point. What will be the reoccurring annual expense, if you know, for the e-filing system?
The reoccurring expense, what the maintenance cost would be? I'm not sure I have that information.
Okay. Thank you, Mr. Chairman.
I think one point to make too, just as simply when you talk about the cost saving, it not only is going to, I believe, be with our court, but it goes down to the courts that are transmitting the records, because they're not having to deal with this too. So you get a hidden savings, if you want to say, with going down to the trial court level.
And though it does not impact public funds, but from the litigant's cost, I presume instead of having to order another copy of everything, because this will be docketed and available on the internet, that then they can do that without having to order another copy.
Go ahead. But Mr. Chairman, I think it would save not only that, but also the public funds, because of the personnel and all that takes that time to do it.
One of the things that our court and the Court of Appeals require of attorneys is when they cite to what happened at the trial court, they tell specifically in the record where that can be found. And typically what the lawyers will do is travel from Savannah to Atlanta, sit down in the office and find those specific record sites and put that in that brief. If we have the software, a lawyer can pull that up on their computer, find the record sites without having to travel to Atlanta and insert that in their brief. They'll save time and money for the litigants.
That's the problem. I've done it myself. You don't have to go to the record, find everything you need.
I think in big projects like this in the past, there has been a problem with people buying stuff and then it not working as advertised. Are y'all comfortable enough with the vendor that y'all have talked to in your prior experience that they can perform for the amount that they have quoted you?
The vendor that we're using right now is the vendor that did the e-filing system that allows attorneys to file briefs with our system, and that has worked very well, both at the Court of Appeals and with us. We did that project for $162,000, and so they've proven to be cost efficient as well.
And I presume that at some point in time, that when we get out of the current budget crisis, that we would be asked to replace some of these staff positions. Will this help mitigate that to some extent as well?
I think it will to some degree. That we will still need additional people. We cannot continue to depend on interns. I think they certainly have helped us during this crisis, but we are going to have to fill a position where someone is there at the front desk on a permanent basis as an employee. As I said before, I think that this may remove the need to replace someone in the records room. There is currently no one in the records room, so everyone is sort of doing double duty in the clerk's office. Will there be possibly positions or a position that will not have to be refilled? I think that's a possibility.
Okay, and I have we've got a couple other questions, but I've got one follow-up question to Justice Melton, if I could. If there were an investment in this hardware and software, as I believe the Chief Justice said, there's a potentiality for replicating it in the Court of Appeals for additional savings there. The hardware evidently would have to be purchased in both locations, but would the software actually only have to be purchased once?
I think that would need to be worked out. What our pattern has been with the Court of Appeals and with this vendor is they worked with the Court of Appeals initially on their attorney filing, e-filing system. We were able to take what they were able to do and upgrade it. So some of the cost of having our system figured out was already taken care of. We didn't have to start from scratch. And the vendor is already working cooperatively with the Court of Appeals, and the systems are compatible in large degree, so they would be able to pick up where we left off and not have to duplicate at least the information gathering process. To what extent we can share software, I'm not sure at this point.
All right. Representative Burns.
Thank you, Mr. Chairman. Justice, I guess some of us are a little challenged by IT. I'm up to speed. I can spell it now. But I would certainly encourage y'all in my small business, the challenge has been making sure when we got the software that it was easily accessible, it was easy to implement, and didn't take 10 staff people half the year to do it. So I feel comfortable that in the legal profession, y'all are already working with these type these links, and I would certainly make sure that we would make it linkable, if that's the right term, to folks across our state that have business with the court, because it certainly would be a savings for the people of Georgia if we could not have attorneys traveling from distant points in our state here to just copy records. So thank you for how you're pursuing that, and we've had some great questions along those lines, but I know y'all are, it sounds like a good project, and I hope we're able to fund it. So thank you.
Representative Weldon. Turn on the mic button on the back. Yeah. One more time.
As you can see, I'm up to speed on this IT stuff too. I'm not sure I can spell it yet. I want to thank you for being here, Chief Justice and Justices of the Supreme Court and Madam Clerk. Now, I want to applaud your work dealing with this situation we've been faced with the budget. I was just wondering if the interns that you have filling in for clerks and other positions, does the clerk look after them and make sure they're doing what they're supposed to do, or is it requiring that you guys be more involved with that also?
Our clerk looks over them and gives them their duties, and I have to tell you, I don't think we could have gone through this budget crisis without the clerk that we have. She has done yeoman's work, not only as far as the staff is concerned, but she and the deputy clerk work weekends and nights to make sure that things are done correctly. It's the only way we can keep the court running.
That's what I expected, but I appreciate your work. Thank you. From District 3 and the rest of the state of Georgia, we certainly appreciate your work.
And our clerk is an attorney, and a distinguished attorney, and not only that, worked at one time with Justice Melton. So, we and with also the chief. So we've been fortunate to have that wonderful experience that came in, and she's been able to utilize that, I think, to keep us afloat.
I think if across the rest of the agencies in Georgia, if we had this kind of work and commitment, we'd probably all be in a little different situation. Thank you, Mr. Chairman.
Representative Baker.
I echo Representative Weldon. Thank you guys for being here this day. I know it just seems like you were here yesterday. As a matter of fact, you were, weren't you? Just a quick question. Under shared services, I noticed that y'all don't do that on payroll. Would it benefit you, or would there be any savings at all to you guys if you did the judicial shared services?
We have one fiscal position, and her duties are not just payroll, which means that even if we should send our payroll duties to the administrative office of the courts, we still would have to have that position because that's not her complete job. However, in that same vein, I am not reluctant to send the payroll services to the administrative office of the courts. We have a new director of the Administrative Office of the Courts. She is working diligently, I think, to serve all the courts, and she's doing a terrific job. Just yesterday I had someone who works for the Domestic Violence Task Force, and he just volunteered that since their payroll and their funding has been put into the administrative office of the courts, they get much better service than what they ever did before. And so this is a group they're hardworking. They are doing the best job that they can do, and I would not be reluctant to have them take over our payroll services. Although, at least for our court, I don't see there necessarily being any kind of savings.
Okay. Thank you. Thank you, Mr. Chairman.
Are there any other questions? If not, thank you very much.
Thank you very much.
Okay. I've turned on your mic.
I was going to suggest if you might remain with us for a minute, because I'm going to go into something with the Court of Appeals about this same program. You seem to be the one that's got the experience and knowledge about it.
You got to give it to the young people.
Yes. We spell IT.
Judge Phipps,
All right.
welcome.
Thank you, sir.
What happened to Judge Ellington?
Well, we tried to get him here, and he would love to be here, but he had an unavoidable thing that he had to attend to, and he sends his regrets.
He didn't want to bring any books to show us this time.
We took that card from him, yeah.
When they brought in the table and the microphone a little while ago, I thought, uh-oh, Judge Ellington's sending us more exhibits.
I know. Well, good morning, Mr. Chairman and members of the committee. You asked Justice Melton to stay because you wanted to address something that he discussed with us. If you want to deal with that first, we can do that. And I would say that the Court of Appeals is in support of that request by the Supreme Court. We do think that that would be beneficial to the court and to the people of Georgia, and the Court of Appeals would benefit from the Supreme Court's project, because it would save us, as they said, money and effort in getting ready for that. Yes.
Follow up with that. That's great, Judge, because one of the things I see is very important is this connect with both courts doing the same thing as far as the IT work, the record transfers, etc. Both courts now have the ability for briefs to be filed,
Yeah.
but we don't have the record information filing.
That's right.
And I don't know, has the Court of Appeals delved into a study of that, and is there something that can be done jointly with both courts? And third question, first follow up on this, is it something that should be perhaps assisted through AOC, either for the licensing of the materials through one governmental entity that would be shared by both courts, one purchase of IT equipment that could be potentially shared by both courts?
Well, I think probably Justice Melton is better
That's why I asked him to
qualified
stay.
respond to that.
I think the answer is that we are sharing a good bit. Some of the software will have to be customized, but we are using the same vendor. We do have a IT committee that Judge Phipps sits on, I chair, AOC has staff members, so we all are working collaboratively.
Okay. I guess my question comes when I look at the Court of Appeals budget request. I don't see anything in there dealing with the point. So.
Yes, sir. I'm the clerk of the court, Holly Sparrow.
Yes,
and
ma'am.
I believe I can answer your question. Although our court started with the electronic filing first, that was followed by the Supreme Court doing electronic filing. but our electronic filing is limited right now because of our old docket system. We're working to replace that docket system right now. Until that docket system is complete, which we hope will be sometime this summer, we would be unable to do an electronic records transmission project like the Supreme Court. So we have to kind of wait in step, and that's one reason why we want to support them so that they can get it started, and then while we're getting our docket system revised, we will then be ready to make, that next step. And we would probably come back to you to ask for some additional money to do the same thing the Supreme Court is doing.
My question goes to sharing of the hardware equipment.
Right.
Are we going to be able to do that?
There will be some
or will it
sharing.
be separate?
There will be some sharing of hardware and some sharing of software, but I think we will have to buy some additional software license. I do believe that we don't really need AOC involved in this project because we have been working, like the Supreme Court, with the same vendor. And this vendor has done the electronic filing for both courts. The dockets is working on the docket for ours right now, has worked on the Supreme Court docket, and will be working, it looks like, on the records project. So we have a direct link. We're all connected to that. We're both working with them in cooperation. So I think this is probably the best situation for us to continue down that line.
So what I'm hearing is we're having the Supreme Court first go forward,
Correct.
set up their system, and then you're not talking about then fiscal year 2012, but perhaps fiscal year 2013.
Correct.
Coming in with the Court of Appeals. Okay.
Correct.
Let me follow up on that just for a minute, and maybe you and Justice Melton might want to both jump in on this. But it would seem to me, even though you're using the same vendor, that if you jointly submitted a request for proposal rather than the Supreme Court doing that, and then at some point in time later on the Court of Appeals requesting some pricing, by that time they've got the Supreme Court's money, they've set up that system, there's not really an incentive to cut the best deal for the Court of Appeals, and that's just sort of a gut reaction to the way that people do. Whereas if you've got two buyers on the hook, you have a tendency to want to keep both of them rather than picking them off separately. And so I understand the time constraints, but it seems to me that to get the biggest bang for the buck, that maybe we ought to have some joint submissions by both courts, and I'd let either one of y'all can respond to that.
I just think the answer is we probably need to look into that.
I don't think we would have any problem with trying to work with a vendor jointly to do that. Our only concern right now is we're not in a position to start in the Court of Appeals right now. So, there may be some limitations on that, but I'm sure we'd be happy to work on a joint proposal to the vendor.
Well, we're talking about the fiscal 12 budget, which starts July 1, and you said that you would have the upgrades in place sometime this summer. So, if the Supreme Court has started on it, it would seem to me that that might be a good time for both courts to be working on this together.
We would certainly be happy to work on that and give you an estimate if we can figure that out timely enough.
Well, if you could, and get it to Kendra, so that if it were something that you had some realistic numbers on, and if it were something that we decided to try to fund in this fiscal year, then certainly we would need some numbers so that we could do both courts at the same time and hopefully save some money.
We'd be happy to do that.
Okay. Who's 19? Representative Baker.
Ms. Sparrow or Justice Milton, either or, the vendor that you speak of, is that a local vendor?
No, it's not.
And where are they out of?
Utah is where they're. Well, Virginia. That's right. Their headquarters is in Virginia.
And I'm just curious now. There's not a vendor locally that had this software or this program that y'all went to? No.
This is not a program in a box. It was developed specifically for our courts, and so we we all looked at various vendors. We made our choice based on what they could do for us, and I think as Justice Melton spoke, we would consider that we got a very good deal with what they have developed for us in the electronic filing. I don't know if any of you attorneys that are on the committee have tried the system, but we have had a lot of success with the system, even though the Court of Appeals is actually somewhat more limited than the Supreme Court system at this point. Attorneys love it. They say it's better than the federal district and appellate courts. It's very, very simple. We have had a drop. We have a, y'all may not, this sounds sort of silly, but we have a box on the first floor of our building. It looks like a mailbox. And it is used to drop filings overnight so that people can have a chance of getting that there with an overnight date. It is empty almost every morning now, where it used to be full of things. And it is because the people, the attorneys, the parties, have an opportunity to file up to midnight of the day through the e-filing system, which they love. So in answer, I say I think we got a very good deal from the vendor, and because if you're consistent with a vendor, we know that we get component A, we put component B on it, like what we're doing now. We started with e-filings, we dropped the docketing, and vice versa with the Supreme Court. And now the next step is to put that records on. If you in midstream stop and pick a different vendor, you often are going to spend more money and more time trying to get that third piece up, because they're really all of a part. They make a system that works throughout for it.
Yeah, you'll have a problem with compatibility.
But understand my question.
Yes, sir.
Did y'all seek the vendor?
Yes, sir. We didn't seek that particular vendor.
You put out requests for proposals,
Yes.
is that correct?
Yes, sir.
And the only reason I ask is, we're trying our best to keep our business
Right.
in the state.
There is
And-
no, excuse me, go ahead.
And so I can appreciate what you did, but you're telling us that no one in Georgia was capable of doing
Yes.
this program.
I would say that. There are very few vendors who've worked on appellate court systems. And when we started this project a number of years ago, there weren't that many people who were ready, who were willing to put an appellate system together at exactly how we want it to be. And there are a lot of people are out there doing trial court systems, but very few doing appellate systems. So I would say at the time we started this project, there really was no one in Georgia that was ready and willing to do what we were asking.
Thank you.
Other questions from the committee? Yes,
I didn't
sir.
mean to appreciate Justice Melton, you staying with us for that point. I want to get some connection there. I want to go to the subject again that I was asking Madam Chief Justice about how the filing has worked out with your court over the last year with the problems that were encountered with cost. And I know your court followed suit with the Supreme Court to allow the attorneys to do record filing. How has that been working out?
The record appendix, we call it the record appendix process. And unfortunately for us, we receive more direct appeals than the Supreme Court does. And unfortunately for us, it has meant shifting of work from the trial court clerk to shifting of work to our clerk's office at a time when our clerk's office has been cut in personnel by about 25%. We get most of the direct appeals come to the Court of Appeals first before coming to the Supreme Court. And as a result, we get those records first. We're the ones who have to solve any problems that exist with the record appendix. So I know a number of the attorneys want to continue it. We've been trying to work with the committee of the State Bar to see whether that is feasible for us, but it has posed problems.
Well, I understand being the first year, does the court currently, and may this go to you, Judge Phelps, does the court currently see that it will be continuing the process, trying to improve it, or what is the position the court has.
I believe the court intends to look at continuing it as an alternative. The court is committed to looking at that.
Because I've heard different stories about it. I guess the point I want to make to that system, the attorneys, I believe, I'm putting my hat on as an attorney now, enjoy and like that benefit to be able to file a record that way. I think what may be needed is just clarification within the court's rules about what is the process and how it is to work. Right. And even set up, if you're going to do it and you don't do it right, there may be penalties involved.
Right. That's what we intend to do and what we would like to do, to just, we did it, what we did last year because we had an emergency situation we had to deal with. We didn't have time to study it, but I think if the legislature is going to go back to the old system in some form, that will give us a little time to study it and get the proper rules in place. And I think it can work if we do that. There's
a bill going through that brings it down to $1, which is still high, mind you. But I think even when you go to Kinko's and get it for 8 cents a page, lawyers will still like that for the opportunity. Right. So I appreciate that. Thank you, Mr. Chairman.
Any other questions? One of the things that was asked to the Supreme Court, and I think y'all are aware of it because there have been some discussions with the House Budget Office about shared financial services and putting financial services through the AOC. If y'all would comment on that, please.
I would like to say that I'm not sure that would save us any money. I think that shifting those services.
Well, it would shift also people.
I understand, but as the Supreme Court said, our fiscal office does a lot of things other than prepare payroll, and I would let our fiscal officer speak to that.
I think they're asking me to speak to that again. Sorry. We have 3 people in our fiscal office, but that's not the only things they do. They do a lot of other services for the court. So, which include things like library services. We do have a court vehicle. They take care of the court vehicle maintenance. They take care of assets management. They do all HR things. It wouldn't just be payroll, which helps with the recruitment. They help with the hiring. They help with things such as family leave situations. They're used for a lot of different situations. They do facilities for us. They do our legal subscriptions. They distribute our supplies. They have many different functions besides payroll, accounts receivable, and accounts payable. I think similar to the Supreme Court, we realize that the one area that might possibly be moved, although I'll tell you why that's not the best, would be payroll. But for us, it does mean that we would may lose one of our fiscal employees because that's a portion of that person's job, and we may not be able to have the funds to keep her to do the other functions. Our fiscal staff, though, is small, just like the rest of the court. In administration, we've lost a lot of people. We've lost 11 people over the last few years, 5 staff attorneys, 3 clerks, 1 fiscal department employee, and 2 floating administrative assistants. This has had a great impact on the court, just like the Supreme Court. Although we do not have unpaid interns at our front desk, we have a different view of the front desk. In our view of the front desk, is one of the most important places in the court to be, and to have someone who knows exactly what to do, because we have the public that comes in that needs help. We have the lawyers that come in and need help. They provide answers to many different questions, and so we like to have a trained person at that front desk. We have had, and we do have, unpaid interns in the clerk's office. We have 2 right now, but they're part-time. They're unpaid, and the only reason that we're probably getting unpaid interns right now is because of the economy. When the economy gets better and the private industry has money to pay, they're going to go off to those places, and that may be soon, because the private economy is, moving up a little faster than probably the governmental part of the economy. So they aren't dependable. And I agree. The Supreme Court does need someone at their front desk that is an employee of the court, because we think that's a very important position. But it's had a great impact on our staff overall and what we're able to do. My staff is very dedicated, and I have one of my deputy clerks was promoted to a new position 2 years ago. She has yet to receive an increase in pay because of our situation. So I just want to point that out. I think and with the additional work that we have had through things like the record appendix, some of the other things like our applications used to come in and they'd be about this tall. They're now coming in this tall. We have to process all that. With that work,
Y'all could fix that by rule, couldn't you?
I don't know. Should we just start making the briefs 10 pages instead of 30 pages, something like that? I think we might have a little revolt on our hands. But we have had a lot of difficulty with the fact that with the cuts, we've had to reduce our administrative staff. We do have, and I want to speak to this because I think somebody may point this out, we do have 2 floating administrative assistants. Those people are vital to us right now. We're using one in the clerk's office to do that front desk, to make sure. And that person is important because, like I said, it is much better to have someone who knows the court that can really help out at the front desk rather than just passing phone calls off. So I just want to make those points. Those floating aides are also used when there's any vacancy or a serious illness or accident situation. This last year we have had senior judges. Those people acted as their administrative assistants because there were no administrative assistants for the 3 senior judges we used during that point in time when we had 2 retired judges and 1 judge who had passed away. When we then had the 3 new judges come in, they trained their AAs, made sure that they know what to do. That's what they've been doing lately. And any time there is a workload overload in one of the judges' office, they assist. And they assist us in the clerk's office when we are trying to plan e-filing, trying to update our docket. It takes time for the clerk's personnel to review that information to help that vendor get it right. They do work that relieves us to make those plans or designs or developments. So I just want to speak to that.
Mr. Chairman, I'd also like to say that the staff of the Court of Appeals has gone way beyond, the call of duty in trying to respond to this crisis that we're in. Our clerk's office and the fiscal office and other staff. And our clerk is also an attorney who has an understanding of what we're dealing with in a way that's unique. And they work many, many long hours. They're often there when I come in the morning and when I leave in the evening. And they're not there because I come in late. I usually come in pretty at a reasonable time. But I'd like for you to understand that the way we have been able to deal with this crisis and with the reduction in staff that has been mentioned is because the people that we have are doing a lot more than they ordinarily were required to do. Our staffing now is at pre-1999 levels, and that was, I came on the court in 1999, and the staffing is at pre-99 levels. And what's important to understand, as you all know, the lawyers among you, I'm sure, understand the workload that the Court of Appeals has. And it's a substantial workload. About 75% of our caseload is composed of direct appeals. And these are usually disposed of by opinions, and opinions require time-consuming research and preparation of opinions that will be instructive to the parties, to the courts, and to the attorneys. And the court is struggling to keep up with this caseload. The caseload has not decreased substantially. So the work is still there. The work is still coming in. I tell people all the time, there's no recession in our business, as you know. And it's very important that we have the staff that's required to keep up with that workload. We also, as you've heard many times, I'm sure, we operate under the two-term rule in Georgia, and that is a very good rule. I'm glad we have that in Georgia. But that means that our cases must be dealt with and disposed of within 2 terms, and or they are affirmed by operation of law. That hasn't happened in the history of the courts, and we don't want it to happen. But it does mean, though, that we need sufficient staff to keep up with this burdensome caseload that we have. You know, unlike many other states, you know, I have a friend who's on the Court of Appeals of Louisiana. Louisiana has probably 1/3 of the population of Georgia, but I believe they have 62 Court of Appeals judges in Louisiana. We have 12 in Georgia, and we hear cases statewide. Of course, they're in districts in Louisiana, as they are in some other states, and as you know, even Alabama has a civil appeals and a court and a criminal appeals court. But this reduction of staff that we've had is also means, in order to meet this budget crisis, we've had furlough days, and we've done 7 furlough days in FY10. This fiscal year we've done 5, and we have 1 a month scheduled for the rest of the fiscal year. And each furlough day makes it more difficult for us to do our work. Even today is a furlough day, you know, at the Court of Appeals that we're taking in order to try to meet our budget needs. But each day makes it harder for the court to meet its constitutional deadlines and get the work done in a quality fashion, as we all want and as the people of Georgia deserve. And we've already projected at least 5 furlough days for FY12, and that's without any additional cuts. So we'd appreciate your consideration. I'm not going to talk much longer because I want to give the clerk, Holly Sparrow, and the fiscal office an opportunity to provide any more details that they think are appropriate to help your consideration of our needs.
We'll really just let you ask questions if you have questions.
Let me ask a question. When Judge Ellington was here, he talked about the number of staff that were involved in basically trundling the record from one judge's office to another. Yes. If we went to the record transmittal, electronic record transmittal that we have discussed, where each judge would be able to access the record from a computer terminal, would these positions, and how many are there, continue to be necessary?
We only have one.
Okay.
And that person has other duties as well as taking the records back and forth to the court. We call that position the file librarian. I think there would be some time saved. Whether that is a whole person or not, I'm not sure. I think the other thing that you have to realize is that we have to have, it is going to take time. It's not going to happen in 1 year that all the records come from all the trial courts that come to us.
I understand. Of course, we're trying to look long term. We've gotten to the point that, you know, we can start looking ahead. We aren't there yet, but we're starting to.
Correct. And one of the things I think that we've learned through the e-filing and the docket project that we have is that sometimes the transition can be hard, in the sense that we have a great e-filing system, but we're still doing a paper system on the side. So we're doing 2 different systems at the same time. It would be much easier if we were on everything is e-filed, you know, because then we'd have one system and we don't have to deal, okay, well, let's see, now I do this way because it's electronic, I do this way because it's paper. That sort of adds to the problem of time, I think.
Representative Weldon.
Thank you, Mr. Chairman. Thank you, Justice Phillips and ladies. Appreciate you being here. Justice Phillips, you said that you'll have a 2-term rule. Could you just help me understand that? Like, when does the term start? When does it end? When, and in context of when the appeals, and I'm just talking the direct appeals. Right. Could you help me understand how those?
All right. I'm gonna let the clerk receives them and gets the process started. So I'm gonna let her explain.
We have 3 terms a year. It's called January, April, and September. and they basically row through that period. When we docket a case, it is docketed to a specific term. And it's not, if it's January 1 of 2011, it is not docketed to January 1, 2011, because we have to have a it rolls forward. Everything keeps rolling forward. So it's actually, that January term for us begins about the middle of August, where we start taking it in August and setting cases to January, because that's when you're going to do the oral argument for it, and that time everything is filed by that time. You start in August, the appellant files his brief, the appellee files his brief, there's a reply brief, there may be motions. So it's all moving up to that oral argument set date. The court has to dispose then of it by the end of the second term. If it was docketed, say in August, end of August 2011, I docket to the January term of 2012. Well, by the end of the April term in 2012, that case has to be out of the court as a decision by the court.
Okay.
Does that answer your question?
I think that does. Thank you.
Are there any other questions? If there are none, we will thank y'all for being here. Before you leave, in the 2011 budget, which I'm sure that you are well aware of, we cut the 2 floating administrative positions, and we put in a dollar figure of about $205,000 or $210,000, which was not adjusted for the fact that we were dealing with a partial fiscal year, which would mean that you would wind up cutting about 8 positions instead of 2. We have made the the House Budget Office aware of that. If you wind up testifying in front of the Senate as far as the 11, make sure that they are aware of that mistake, and it will either be fixed in the Senate or it'll be fixed in conference committee, but y'all need to sort of watch after that, and we apologize for that mess up.
Thank you very much.
Okay.
We appreciate that.
Thank y'all very much.
Thank you very much.
Thank y'all. Juvenile courts, and I'm going to ask Chairman Willard if he will to take the chair for just a moment.
Good morning.
Good morning, Mr. Chairman. My name is Eric John. I'm the director of the Council of Juvenile Court Judges. I have Judge Poole here, who is standing today for our president, who was here yesterday. Judge Bryant Henry could not come 2 days. Judge Poole is from Cobb County.
Thank you, Judge.
Yes, sir.
And of course, I think most of you know Kirsten,
Yes,
our
indeed.
budget director. And I also have a host of judges. I have Judge Pape from Floyd County, Judge Banke from Clayton County, Judge Piegler from DeKalb, and I think you all also know Judge Tilley from
Very well.
Bartow County.
Welcome all of you.
So, and obviously, as you can see in the document, our have no enhancement requests. We're just asking for what it used to be termed continuation budget, or our budget to continue our functions, and that's pretty much there. What I have to say, unless Kirsten has anything specifically to add.
We're just trying to maintain our budget. I have been working with Kendra on what we spoke about in 2011 for administrative assistant who resigned position, that funding, which was a reduction in 2011, which would continue into 2012.
All right.
I'm more than happy to answer any questions.
Sure. Questions of the committee? Yes, sir. Go ahead, Mr. Coleman.
Thank you, Mr. Chairman. Do you guys have a position on whether the administrative office of the court could administer the payroll for the juvenile court judges?
They actually we process all the accounting in office, send it to the administrative office of the courts, and they input it into PeopleSoft and actually cut the check. So they pretty much do it already.
Okay. And what about other fiscal issues that you guys have? I guess that's taken care of at the county level. Is that right? Okay.
I would think so. Yes, sir.
Okay.
We had a discussion last year, Mr. Johns, and with the judges too, but the office of your juvenile court administrative offices have been in Peachtree Center
Yes.
And I think what we discussed last year, that lease was to come up for termination, was it into this year? What are you doing now planning-wise on that future?
Actually, we've been meeting with the Georgia Building Authority and also the State Properties Commission. We actually met and looked at a space last Friday. They're working up plans, architectural plans to build out the space. Also, we met with movers yesterday to get a cost on moving for us to leave that current space and come into state-owned space as of July 1st.
Have you had, and looking at your budget, has that been determined, and is it in your current proposal?
No, sir, it's not. I've been working with Kendra. We're still trying to get the total cost for us to move over, and we don't have that. We don't have the exact number. I know that the space that we've currently decided on over at the Twin Towers would only be a savings of $4,000 a year.
Okay.
But it would be a state-owned property.
Correct. Okay. Yes, sir. Excuse me. I'm getting you on right now. I think you're on. Oh, you got a button on the back here you've got to turn on also. Which number you have?
25, 26.
Let me turn 25. I had 26 on. Is that down?
Okay, this one's working. Does that mean I'm good for
You're
a question
on.
now?
Please,
okay,
excuse me. I'm
Mr.
sorry.
Chairman.
Go ahead.
There's been some questions brought up, and could you kind of explain the history and purpose behind the Permanent Homes for Children's program? And how many judges does it serve, and how does it assist them?
Is it the panel?
Yes.
Good panel.
We refer to them as the Citizens Review Panel process.
Yes.
I understood that subject might come up, so I called my panel people. And in Cobb County, and I can only talk about Cobb, we ran 400 panels last year, servicing over 700 children. We have about 280 kids in care right now in Cobb County. And you want me to talk about what that panel does? Or
Yeah, how does it assist the judges? And
it's a huge help to me. We have 4 judges, full-time judges in Cobb County. Under the law, all these children that come into care have to continuously come before the court so that we can address the issue of permanency. How are we going to get these kids out? How are we going to get mom and dad to step up to the plate so that we can get the kids returned home? The law allows, in addition to the judge hearing cases, the law allows those cases to be brought before a citizens review panel, literally made up of citizens that are highly trained by the Council of Juvenile Court Judges. In Cobb County, and I think this is statewide, each time that citizen review panel meets with that mom and or dad, they spend approximately 1 hour on that case, going over the case plan, the order that I gave so that the child can be reunified with the family. And in Cobb County alone, with 4 full-time judges handling approximately 8,000 cases a year, if I had to spend that kind of time, or my fair share, which would, I don't know when I'd do it, number one. Number two, when I did it, I wouldn't have the hour to spend that the Citizens Review Panel has. There's no way. Citizens Review Panels are very important to the juvenile court. I think they're also important from the standpoint that it brings community participation into my court, our court. You know, these aren't lawyers. These are just folks that are volunteering their time, even though they're highly trained. So it's a big deal to us to have the Citizens Review Panel.
but it's not in every county, though, throughout the state.
No, we have about, I'd say, 65 counties?
Yes, sir.
That have it, most of your metro counties. And if it would be possible, you would indulge us, we did have some judges who are very passionate about this and are from different areas. If they could speak just briefly on it, Mr. Chairman, if that's okay.
That'll be fine, but why don't we see if there are other questions, and then we will hear from them about that. What do the counties that do not have it, I mean, there's 65 out of 159, what do they do? And, you know, our interest is that if there are, you know, 94 that get along without it, how do they do that? And so why is it necessary in the 65? Oh, and by the way, Judge Poole, good to see you again.
Good to see you, sir. Absolutely.
So anyway, if y'all could maybe answer that question, then we'll go on to some other members of the committee too.
Well, of course, I'm not a judge in a more rural county. I'm a judge around here, and just from a caseload standpoint, the benefit to my county is huge. Now, I don't know in a more rural county, if you were a judge, Judge Spivey, who has 8 counties, he's not going to have the caseload that I have, but Judge Spivey has a citizens review panel, doesn't he? He has the citizens review panel to help him. It would be very difficult to function in a metro county without a citizens review panel, in my opinion. So, but I can't speak to the counties that don't have them.
Representative Powell.
Thank you, Mr. Chairman. Kirsten, you asked answered a question on payroll with AOC. You said y'all's fiscal office basically forwards the information over. Do y'all get good results? Y'all have do they do a good job for y'all?
They do a great job.
The reason I ask them the question is for years.
Pull that microphone over, please.
Oh, I'm sorry. I apologize.
For years, there's been a long-standing concern with several of the levels of the courts. They just didn't want anything to do with AOC as far as them handling their payroll and all. And I was curious because yours has been the first positive comment we've heard about this interoperability of letting AOC do this actual payroll performance. But y'all do get a good experience with them.
Yes, they do a great job for us.
If I could, I did have someone give me a statistic a second ago concerning the counties that don't have the citizens review panel, and I've been told that 80% of the children that are in care in the state are serviced by the citizens review panels. So 80% of those children that have been removed by any judge are going through that process statewide.
The citizen review panels are staffed primarily by volunteers, is that correct?
Yes, sir.
Where is the state funding going if the panels themselves are volunteers?
Well, training. Number one, the Council of Juvenile Court Judges goes into each one of the counties with the panel, trains the panel, keeps them up to date, keeps them trained, gives them continuing education, and helps actually run some of the meetings. And they do it in a uniform fashion because they're going to all of the panels in however many counties that was.
All right, Representative Baker.
Might be me.
Tom, 18.
All right, 18, Tom.
Thank you, Mr. Chairman. The panels. Now, your court is not an open court. Is that correct?
Well, after the law was changed, I think it was last year, on those types of cases, it is. On a delinquent case, which you think of as criminal, it's a delinquency case. That is not, with certain exceptions. But on the majority of the deprivation cases, because of the change of the law a couple of years ago, those are open cases.
And so anybody wants to go into your court, they can go in there and they can sit and they can listen. And if they want to go get the records on this, they can go get the records from the clerk. They don't need to get a court order.
No, to get records from the clerk, then they have to, there's a different procedure under the statute for that. Sitting in the courtroom, anyone can come in that wants to come in, but looking at a child's record, a family's record, is a different proposition.
Okay. And that's different from superior courts, which is all open. They might walk in the clerk's office and ask for a file, right?
Walk in any superior court that you want to, or state court, or municipal court, and see basically anything that there is.
And do you think that's probably one of the reasons we need to have citizen overview of or review of this?
I think it's very important that the citizenry knows what's going on in their courts. And when I sit and talk to our groups, including CASAs, that you may or may not know about, and Citizens Review Panel, I tell them that I think it's extremely important that these volunteers, these members of the community, are invited into our court. Because, you know, whether it's open or not, people don't just come sit in the juvenile court and watch what's going on. And I think it's hugely important to have the citizens come in there in that capacity. And, you know, I don't know, I should have gotten for you how many we have, but I'm sure it's well over 100. I mean, we have, I think, 68 CASAs right now in Cobb County. That's in addition to the citizens review panels.
Thank you.
If I could just say one more thing, what kind of sets the juvenile court out from the other trial courts? I mean, they're obviously different from the appellate courts. In your typical juvenile court case, in a deprivation setting, where we have removed a child, we keep that family in front of us for months. It's not like in the superior court you might hear a divorce. You make your ruling, they're gone. It's over. Not in my court. If I take that child, and people could be laughing because there's going to be 14 contempts and modifications filed in those cases. But if things work the way they should. But if things work the way they should in juvenile court, if they work the way they're supposed to work, I'm going to see those people every 30 or 60 or 90 days. I might start off every 30 days. I might move to every 90. The Citizens Review Panel are going to pull these folks in twice a year. And our panels have become so important to me personally that I have gotten with my panel coordinator, and I'm running cases through my panels that are not defects cases anymore. Cases where I've released the Department of Family and Children's Services. I've given the child to grandmom or to an aunt or uncle. And I'm letting those cases, some of those go through my panels so they can sit down with these citizens for 1 hour. 1 hour is what they usually do, to talk to them about what the judge has ordered, what we need to do, and to get these folks, you know, back reunited, which is our goal, is to reunite the families. And so you have to think about juvenile court as a continuing case that judge is going to touch multiple times before either the child goes home or we have what we call the death penalty of the juvenile court, which is a termination of parental rights. And the panels are intricately involved in that process.
Chairman Willard.
Thank you. Mr. Johns, let me get down a little bit in the weeds of this. We have CASA, we have the review panels. What is the difference between a CASA representative, which is like a guardian ad litem? Maybe, the judge, you might be the better answer.
I'd be happy to.
Sure. I'm trying to get to
two distinct.
There is.
CASA is a court-appointed special advocate. It is a person.
Yes.
Might or might not be a lawyer. Some lawyers donate their time to my court. They are highly trained to be a voice or an advocate for the child.
Who trains them?
They're trained through the Council of Juvenile Court Judges and the county folks.
Okay.
The Georgia CASAs, the Georgia CASAs are trained by the Georgia CASA Association of Georgia. They've got their own entity.
They come to us.
Okay.
They train them. Now, in Cobb County, we have our own CASA coordinator who does all of that.
Okay.
So in most of these cases in Cobb County, the child would have a guardian ad litem. It would be a lawyer. And in addition, in certain cases, we'll have a CASA. The CASA is a benefit to the guardian ad litem. It has the authority of the court. That CASA would go in to talk to counselors, teachers, principals, doctors, and all of that, so that when I bring that case in every 30 or 60 or 90 days, that CASA is in the courtroom with us, giving a report and talking to me about what's happened and what he or she thinks is best for the child. The Citizens Review Panel is on a different floor. It has nothing to do with the courtroom.
And Judge, I can see the difference. The question is, we don't, by state funds, train CASA, and Mr. Johns, we're doing state funds for training of these other groups as volunteers. How much are we spending annually in the groups for training?
For the field staff, the salaries total for a year is about $540,000, and then additional about $30,000 for travel.
And I'm assuming there is a standardized training manual that is used for this, and I'm questioning why is it not just something handled on a county level as far as doing it with through the juvenile courts as opposed to a staffing of the state level training. That's our main issue here. We're concerned and questioning, do we need to have state funding for this, or is it something should be recognized for a local level as a part of the funding?
Well, number one,
like we do CASA.
it's got to be, in my opinion, uniform, because the law is the same in all 150 counties, and we've got to have the program the same. Well, I would think
it could be uniform, but by virtue of the fact you acknowledge there's a training manual that takes care of this training process. There's a court's oversight of being sure the people who are involved as volunteers do have the appropriate training. Correct? So back to the
assuming
point.
There's a manual. I haven't seen it.
Well, for God's sake, I hope there's a manual.
Yeah, absolutely.
But I'm coming back to the point, as we're examining programs the state takes on and continues as a process, why is there a need to have that as a continuing state-funded program?
If y'all would permit.
Well, we'd love to.
Velma Tilley, Bartow County Juvenile Court. I've been in this, doing exclusively juvenile court work for 23 years now, and almost 12 years as a SAG, and now 11 years as a judge. I would suggest that the difference there is that CASA has an umbrella state organization that monitors what they do and how they send their training down to the county level. They could not do that without the state level umbrella organization. And that to take this away really would be just penny wise and pound foolish, given what it means to us at the county level. I, in fact, have a county paid coordinator. But if she goes away, as at one time they did, and then I stole a DFACS worker to come and be my county coordinator, I would need the employee from the council to come in and bridge that gap. And that's what they do. These folks, field coordinators, bridge the gap. And then as new judges come in who haven't had panels for a period, might want to have a panel, they have to have somebody that's experienced. I can't send Carolyn Johnson from my county over to, Cobb. I need her in Bartow, to either train or...
Okay.
That's just my suggestion on that.
I really understand, Judge. We're facing budget crisis, as everybody is, and I'm saying from a program, do we need to have the full staff we're talking about? Do we need to have a bridging of the programs where there may be a need? Do we need to have someone who goes into a new county or county wanting to set up a new program and assist them that way, as opposed to continuing full staff? I know we cut back 1 or 2 last year. Voluntarily it was done, but I'm saying we look at a full staffing now of 11 members. 10 members. Is there a need to
really address what the benefit this is to our counties and how we move children to permanency? And I just want to tell you that while they have in Cobb, my neighbor Metro County has 280 in foster care. In Bartow, with 2 judges, we have 220 children in foster care.
I understand. I'm not disputing the benefit of the program. I look at the law. The law recognizes, acknowledges there will be the voluntary program. The question is the funding of the need at the state level as opposed to being oversight by the local juvenile courts who desire to have that program.
If you will, try to come around someplace where there's a microphone, and so that because this is being streamed other places.
Y'all are aware that the law, both federally and state, requires a review every 3 to 6 months of these cases.
By the court.
By the court. The only way the judge doesn't do that is through the panel. So what the panel is doing is performing a judicial function. That is, that's a very different function than somebody who is like a CASA who is coming in and just telling the judge what's going on with a child. This panel is forming a judicial function without consistency. What you're doing, and without monitoring from a state level, what you're doing is you're creating a system that is very haphazard and that is not going to have judicial consistency and is not going to rise to the level of what you would expect from a judicial decision. I'll be honest with you. I've had panels. I was one of the first 3 counties to have a panel. I wouldn't have panels but for the necessity, given the number of cases, of I don't have judicial time to be able to accomplish this. The reason I wouldn't have panels is because citizens, as much as we want to say are well trained, are not going to, on once a month, come in and be able to monitor these cases and do the kinds of things that they do without somebody trained from the state being there with them to keep them on track and to be able to make sure that these folks perform a judicial function, which is much more complicated than just sitting there and having a nice little conversation. They're actually having to look at how the case is progressing, how the parents are progressing, talk to the parents about progressing, making sure DFACS is doing their kinds of things, all the stuff the judge has to do. Without that, I'll be honest, if I don't have panels, what you're going to end up with is you're going to put at risk federal funding, because without the panels, the judges are not going to have the time, and you're liable not to get your federal funding.
I'm not arguing about having the panels. I'm arguing from the, I don't call it arguing. I'm addressing the funding need at state level of what we're talking about as to 10 people going forward doing something around the state, as opposed to your county having one set up, getting started and having the initial beginnings and training, and now the juvenile court take over that part of the program with the manuals that are furnished for that purpose.
I've still got to have a personnel at the local level to be able to keep these folks on task and to train them.
Yes, sir.
And that means what you're doing is shifting the responsibility to my county. My county's in the same budget scenario. They're not going to pay for it. They're not going to give me the personnel to do it. Right. And I'm going to end up having a judicial function that's being run in a way that cannot be accomplished.
Okay, that's my question. Do the courts locally have people that do this? So it's all done from the 10 people at the state level traveling around to each county training groups?
Training and sitting in the panels, making sure the panel itself is focused on the questions and the answers they need to have so that they have that judicial function well directed.
Thank you, Mr. Chairman. Thank you, Judge.
Let me ask you a question that may or may not, initially it doesn't, but it may ultimately. Changing gears a little bit, filing fees. Are there filing fees for any cases in juvenile court?
No, sir. We
All
don't
right.
have filing fees.
Then my second question, and this was brought to my attention not too long ago, in deprivation proceedings. You've got the DFACS deprivation, the state initiated deprivation. But you also have private deprivations which are somewhat akin to custody complaints. Do you have a feeling for those as to how many there are, and whether or not that, I'm not going to ask you to make a judgment call as to whether or not they should be filed and whether they are disguised custody cases. But in those cases, if there are enough of them, should there be a filing fee?
It wouldn't bother me to have a filing fee, sir, but there are so few cases in my court that are not initiated by DFACS that I don't even know what the number is. I don't get one a month, you know, something like that. Now, there are cases that are not DFACS initiated, parental notification cases, cases where medical care is being, you know, withheld in a hospital might come in. That might not be DFACS. We get probate court transfer cases. But what we call private deprivations are so few and far between that it would be insignificant to my court.
What about legitimation cases?
Legitimation cases are almost always run hand in hand with a deprivation case. Well, we've got a dad. Either he comes in voluntarily or we go find him, serve him, bring him in, and part of my case plan is you've got to legitimize that child. We do it with the case. There's no corresponding cost to the system, so to speak. 98% of the times they're by consent. There might be a DNA type test, but as far as any type of filing fee with that, I would say that
now you want to encourage rather to discourage that. I understand that.
Sure.
But if there are cases like legitimation cases that are being filed in Superior Court and initiated in juvenile court to perhaps avoid the filing fee or get around the filing fee. I was just interested if there were those kinds of things where there's maybe some court shopping going on.
I don't think so. The court shopping we see is a custody case that needs to be in Superior Court. And when it comes before us on our 48-hour hearing or probable cause hearing, and we spot that this is a custody case, it's going out the door anyway. Doesn't happen that
I'm
often.
glad you don't practice in my circuit.
I understand. You also have to think that a huge percentage of the cases that are filed for legitimation have court-appointed counsel, and they've qualified through our circuit defender as being basically indigent. So there's not going to be any increase. And if we had a filing fee, it would be minuscule in those cases.
Okay. Are there any other questions from the committee? There were some other judges, I think, that came and wanted to talk about the panels. And if you would, come around and take a seat so that we can hear from you, please.
I'm Van Banky from Clayton County. We have one of the older panel systems in the state. Judge Glaze set it up in 1986, and I don't know what we'd do without it. We have anywhere from 200 to 300 children in care at any one time, and we did around 170 panels last year. The training that the state provides, both the training director, which is Mr. Bassett, who is here, and the state reps that are responsible for the counties, they keep everybody in line. We do have some panelists that have been around a few years that are very helpful, but just the humanity of the process is something that I can't replace. And otherwise, I can't match the eloquency of Judge Pape.
Good morning. My name is Desiree Piegler, and I serve as the Chief Judge in DeKalb County. We have a total of 4 judges. We are also the beneficiaries of one of the panel programs. We've had our program since 1991. We currently have about 120 volunteers. If I could speak specifically to your concern about why we need the state intervention in this, the number one reason is for the training, but more than that, it's someone to track the data, someone to make sure that we are following the federal guidelines. If we don't do that, then that is going to be a loss of monies to the state also. To specifically answer your question about what we could do from a county level, quite frankly, in DeKalb County, I don't have anybody extra to do this function. We have a staff member who is specifically assigned to the panel review process, but that is not someone who sits in there and makes sure that the information is obtained and that the process runs in an efficient manner. I don't know if you all have had an opportunity to hear the news just this morning, but in DeKalb County, the proposal is to cut $33 million from our budget. That's close to $1 million to the juvenile court budget. We're talking about possibly 800 layoffs in DeKalb County. Last year alone in the early retirement program, I lost 15 veteran employees. So that's the sort of challenge that I would have in DeKalb County if we didn't have the state providing those much-needed services to our panel review process.
Any questions from the committee? Thank you all for coming.
Thank you.
Judge Poole.
I just want to make sure the committee's aware of one thing.
Come back to the microphone.
That I don't want the community to get the feeling that the state funding is only for training. And I don't want you to think that when these valuable citizens are sitting around hearing these cases that they're on their own. One of these people that we're talking about that you provide is in there running the panel. All right, so this is
one of the 10 people we're talking about.
You've got your citizens, and each panel is going to have X number of citizens. But Ms. Ragsdale is the employee that's going to come to Cobb County. She's running those. It's not the citizens are sitting there, with sort of a manual going down a checklist. She's not only providing the training, she's running the panels. And when she's not in Cobb County running the panels, she's in another county running the panels. So it's not just a training scenario, it's actually putting it into place. Monitoring.
Any other questions? Thank you all very much.
Thank you.
Thank you.
Superior Courts. Welcome back.
Thank you. Thank you. Glad to be here. I appreciate the opportunity to talk to you about the fiscal year 12 budget a little bit. I want to emphasize just a few points before we look at the actual proposal that we gave you for the 12 budget. The first is our history that we have cut from 2009, amended forward. Every time we've been asked to cut a specific percentage, we've done that. And it has been painful, but we have managed to do it. We believe that the Superior Court budget is now very efficient. The District Court Administrators and the Counsel Office are the administrative arms of our budget, and that is only 5.8% of the total budget. We feel that's very efficient and streamlined. Revenue, Superior Court's generated nearly $500 million over the past 5 years. You heard, I think, yesterday in the Chief Justice's State of the Judiciary talk that in 2009, 449,000 cases were filed in the Superior Courts in Georgia. Of the judges' program budget, not the District Court Administrators and not the Counsel Office, but in the judges' program budget, 98% of those current funds are allotted for legally required items that we have to do. We have given you a proposal that looks at a 6% cut, which is what we were asked to do initially. And so what you see in front of you are what a 6% cut would do to us in the fiscal year 12 budget. The DCAs would impose 12 furlough days. The senior judge program would essentially go away. It would leave a small emergency fund of $194,000. The 3 vacant law clerk positions, although we did eliminate 5 in the fiscal year 11 amended. So we could add 2 more to that. That would be another $107,000. And then there would be furlough days for secretaries, law clerks, and court administrators. In the counsel office, there is the 1 paralegal position that would be left out. And you know the counsel office is operating now at 1995 levels. They had 15 staff, they now have 11, so they're operating at a much reduced level than they have in the past. I welcome questions.
Chairman Willard.
Thank you, Judge. Happy to see you again.
Thank you.
Tell me some more. We've had discussions, I believe, about the judicial administrative districts that were set up back in the 70s.
Yes.
And what is the council's position on trying to, I'll call it, modernize that system?
We would be glad to look at that system and see about reallocating and shifting people around. It has changed significantly over the years.
What is the current functions of the administrative district?
We have Greg Jones here with us, and he can tell you again what the DCAs do. But let me say first that those duties are very different depending on where you are in the state. And I've learned this just from being in the leadership of the council, but the rural circuits need those court administrators to do basic functions.
It's not a handbook.
That's right.
The panels, okay.
No, but the metro areas have different functions. But Greg can tell you a little bit about the DCAs too.
Yes, sir. As you're aware, the district court administrators were created back in the mid-'70s. I don't know the number of judges that existed back then, but it certainly was not the 205 that we have now. Our staffing pattern is exactly the same as it was in the mid-'70s. There are 10 district court administrators and 1 secretary for each district. We provide daily essential services directly to circuits and to the district. My geographical area is where I am. That's the only place I go. I serve only the Superior Court judges in my district, all 17 of them.
Where's your district? I'm sorry.
It's the 3rd Judicial District, which basically encompasses the Macon Circuit, the Houston Circuit, Southwestern Circuit, which is Americus, and then the Chattahoochee Circuit, which is the Columbus area. So I go basically from Macon over to the Alabama line. They vary in size greatly, though.
Do you have any tie-in with other courts, for instance, oversight of working with the state courts in those areas, or the juvenile courts, or the probate courts?
We do on occasion. We do work jointly on some programs with them. In particular, when we've got cases that arise in the other levels of court where the judge or judges have to recuse on a particular case. In the majority of courts, their rules actually provide that the district administrative judge, who is a Superior Court judge, the district administrative judge and the district court administrator will actually bring in judges from other probate courts or other areas to hear their cases.
May I follow up one other point, Mr. Chairman?
Yes, sure.
As to the placement of the judicial administrative districts within the Superior Court budget, do you only work with the Superior Courts or into their jurisdictions, as opposed to a tie-in with the administrative office of the courts? What's the relationship between those?
From a working relationship or a
both? Financial, both courts?
Yeah, from the working relationship, we provide primarily direct services to the Superior Courts. However, we also sit on committees involved at the Judicial Council level as well. Now, from a physical aspect, we are strangely tied to the AOC. Apparently, back in the mid-'70s, before I was a district court administrator, when the positions were created, their physical payroll services was actually placed with the administrative office of the courts. So the 10 of us actually have a tie-in directly with the AOC for physical support.
Here's my wondering question about that is, your services as a district administration of courts encompasses, in my mind, more than just the Superior Courts. Would it be more appropriate function of the district administrative offices being a part of AOC, covering all the necessary court functions and works within a district, once we do any kind of realignment, if there was to be one?
That could be, but you're greatly expanding the capacity of the 10 of us when you start expanding out to the state courts, the municipal courts, the magistrate courts, the juvenile courts, probate courts.
We have a need of getting information from those courts also, and we're not doing a good job of it.
Yes, and the AOC it does an excellent job of the global review and support and assistance to all the levels of court. Good. We're primarily assisting Superior Court judges with direct day-to-day operational matters.
Okay. Thank you, sir. Thank you, Mr. Chairman.
Other questions from the committee? Talk to me about the clerk positions, the law clerks. I mean, there are some that are statutorily mandated per circuit, and then some that have just been added over the years as funds have been available.
There are 50 law clerk positions that are statutorily mandated, one for each circuit, and then there's an extra one in the Butts County because of habeas cases, death penalty cases. So those were originally statutorily mandated. Then there were other law clerks that came about in several ways. One, as a function of a bill to allow a new judge. At certain times, they also allowed a law clerk for that. The legislature did. You did. And there also was at one point, there's been a goal over the years that we should have a law clerk for every judge. That's been a goal, and we've had to back off of that over the years. But at one point, when we had money in the state and everybody was with that goal, there was a one-time 10 additional law clerks were built into the budget one year. I don't remember how long ago that was. 2002. Okay. So that's how those clerkships have come about. But we have frozen them for the past 2 years so that when they become empty, those non-statutorily originally created ones, they're not filled. So.
All right. So right now, how many non-statutory law clerk positions do we have that are filled?
17. 50. 11.
All right.
11.
There are 11
if we
that.
cut those 5.
Right. There are 11 that are currently filled, and those are state-funded positions.
Yes.
Now, are these somebody just out of law school who clerks for a year and then they move on to private practice or to some other position?
It depends on the circuit. Some are that stay for a year or two, and a few are staff attorneys that stay for longer.
How many would you anticipate would become vacant in the next year?
It's generally been about 4 or 5 a year.
Okay. Right. The senior judge money?
Yes, sir.
Is that money that is rolled over from year to year, or is it newly appropriated every year?
Newly appropriated every year.
Okay. And of the amount that is currently appropriated, do you anticipate utilizing all of that?
Yes.
How many folks do you think that are out there that are actually volunteering their time because of the fact that they know that there is a need and are not being paid?
A few.
Yes.
But there are some.
There are a few.
So the need is greater than what the amount is available.
Definitely is. And then some areas, counties have picked up some cost.
In the past, there have been some abuses in certain places. Have the either judicial districts or the judicial council or someone, or maybe the council of superior court judges, have instituted some changes so that those abuses cannot and do not happen?
We did. We instituted several procedures and regulations so that internally we would keep on top of that and that those things would not happen. There was also a change that allowed billing to be done at less than a day's pay so that could address some of that as well. Somebody just shows up and is there for a portion of a day, they bill for a portion of a day as opposed to a whole day.
Okay. Representative Weldon.
I would.
Anybody else? Gosh, you must have done such a good job last time that there just aren't that many questions this time.
Well, we appreciate that. Thank you.
We appreciate you offering up the senior judges, and we will probably again refuse you.
Well, that would be great. we don't want to offer them up. We just don't know where else to offer up anything. So
Okay.
we're stymied about that. You know that they're a good bang for the buck for the state.
Thank you very much.
Thank you.
We'll now hear from the Judicial Council.
Is Kelly coming?
Where'd Jeff Davis go to? Yeah. You want to come up here, and we're going to probably deal with JQC at the same time that we do with Judicial Council.
Do you want to start with him? Okay. Thank you. I appreciate, again, being able to come before you and talk to you about something that's very exciting to me, and that is working with the Judicial Council and the Administrative Office of the Courts. The Judicial Council, as you know, is a policy-making body made up of the leadership of every class of courts, including the 10 judicial administrative districts. It sets the policies and priorities that affect or require the participation of the entire judicial branch. So, having said that, my boss is that Judicial Council, which includes every class of court, every judge within that class of court. And our office works for them and provides services at some level for all of those courts. One of the things that we know about the judiciary, those of you who are attorneys and those of you that remember your civics classes, is that the judicial branch is set upon precedent. Well, the judicial branch, the courts have to be that way, but our administration has to look forward. We cannot stand on status quo. We have to keep reinventing and redoing our processes in order to make sure that our courts can run as efficiently and as smoothly as possible. And that is where my office comes in at the state level. We have before you some limited requests that affect our fixed costs, our operations, and those subprograms and programs that provide vital and sometimes mandated services. The AOC subprogram is requesting funds to cover fixed cost billing increases, funding for implementation of the Access of Justice Legal Needs Study recommendation from 2009, and the Civil Legal Services to Victims of Domestic Violence subprogram is also requesting additional funds for its grants. Additionally, the Judicial Qualifications Program is requesting funds to cover expenses related to the investigation and prosecution of judges, and the Georgia Resource Center program is requesting funds to ensure that indigent death sentence inmates are adequately represented in legal proceedings. At the same time that our operating budgets are consistently reduced, we are seeing our fixed costs continue to rise. In addition, while state government is certainly feeling the strain from the economic situation in which we find ourselves, it must also be true that our constituencies are feeling it as well. It is for this reason that we decided to request some additional funding for free civil legal services for victims of domestic violence. We estimate that an additional 250 people will be able to receive these services if the enhancement is approved. Low or no cost legal services are the only alternatives that most victims have to access the justice system. Providing these services saves taxpayers money, as they help clients break down the barriers to employment, keeping them off of our rolls, help them to get the housing that they need so we keep them off the streets. Also, it helps keep our children out of foster care and helps recover child support. Roughly 5,000 clients were served last fiscal year, and 1,155 advocates, judges, and lawyers received training with the funds. We have an operating deficit related to PeopleSoft billing increases. We have no formula from them to help us anticipate what costs will be, and new billing comes each year after the budget is finalized. So we are asking for an additional $24,916 for that. We were able to give up space in our satellite office in Macon, which saved us a good amount of money, but we also, last year, were required to take on some additional functions. The Office of Dispute Resolution, the Family Violence Commission. So we are asking for some additional funding to cover the space. We are in now lower cost space. We are also looking at reviewing our space, making sure that it meets fire code requirements. And we are also in the process of purging our files, getting rid of our paper, and that's going to give us a savings as we are able to give up off-site storage space. One of the programs that we have is the certification of language interpreters in the courts. We have been able to participate with states across the country in a national consortium, and that national consortium provides us the tests that we need in order to certify language interpreters for our courts. That consortium is a great deal because the development of these tests, depending on the languages, goes from $10,000 to $15,000. With an annual, they have just increased the fee, with an annual fee of $6,691 per year, we are able to take advantage of that. And we currently have interpreters certified in 11 languages. Now, we only have 143 interpreters, I will say, and most of them are Spanish, but you also know that we are under the gun with a DOJ directive, which could affect the federal funding that comes to Georgia if we are found to be lacking in these resources in our courts. So we ask that you help and make sure that we have the money to continue as part of this consortium so that we can continue to train and certify interpreters. You also know that the most recent census report shows that Georgia had a huge increase in its immigrant population. That is a direct effect on our courts. We have a request for the Access to Justice program. This is related to implementation of recommendations from a comprehensive 2007-2008 legal needs study of unmet legal needs for low and moderate income Georgians. Roundtables would be held statewide to address oversight and coordination of resources, legal delivery services, and the development of new programs on a local basis that promote access to the courts and justice for low and moderate income Georgians. This funding would allow staff to implement this program and provide administrative services and guidance of these local meetings by coordinating the organization, agenda, mission, support, and follow-through of these planned quarterly meetings at the 12 different locations. The AOC request for personnel is related to 2 critical vacancies that are currently not funded: a manager in the Court Services Division, which has 42 employees, and a data services manager in IT. The JQC request could provide funds to pay for the costs associated with the trial of judges that concluded with the removal of the judge from the bench and for monies to cover the upcoming costs associated with the formal charges to be filed against several other judges. The increasing pace of investigations has forced them to use its basic operating budget to cover the costs of investigations. And I know that Mr. Davis will be able to talk to you more fully about that. The Georgia Resource Center request for FY11 is intended, for 12, is intended to make up for the shortfall in funding by the Georgia Bar Foundation in FY11. And we anticipate that, I think that we have the director here who can talk to you about their specific request. Are there questions? Got to be by a microphone. Does the podium work?
Good morning. I'm Brian Kammer. I'm the director of the Georgia Resource Center. I think several of you know me and know the Georgia Resource Center. It is an independent, nonprofit office, law office established about 20 years ago through joint efforts by the Georgia Supreme Court, the federal judiciary, the Attorney General's office to ensure that indigent prisoners who have been sentenced to death get adequate representation in their post-conviction proceedings. That's state and federal habeas corpus proceedings.
Excuse me for a minute. You aren't talking about appeals. You're talking about habeas.
This is habeas corpus. Correct.
Because the indigent defense pretty much carries through the initial appeals.
That's correct.
Okay.
defendants are entitled to an attorney, an appointed attorney, if they can't afford one, through the direct appeal stage in any criminal case, including capital cases. But there is no entitlement to counsel in post-conviction proceedings. However, the habeas corpus proceedings have become a critical part of the death penalty system in Georgia, such that the federal courts found it so critical that they wanted to set up an office to help handle representation at that stage. It has become a necessary component of the system of review of capital cases. And as I said, we've been around for 20 years, and we have helped to ensure that Georgia's capital punishment system functions and leads to fair and reliable resolutions, be that execution or should a constitutional error be exposed in the course of the trial, some other resolution like a life without parole sentence might be another outcome. But as Georgia has carried out executions in this state, I think it is fair to say that the work of the Resource Center has helped to ensure, particularly that the federal courts see that process as fair and thorough and reliable. Without the thorough review that we are able to facilitate in post-conviction proceedings in capital cases, I don't think you would have that. And in fact, in cases where about 15 years ago, for example, we were defunded by the federal government. We were getting some money from the federal government. And some prisoners had to go through state habeas corpus proceedings without an attorney, particularly a guy named Xavier Gibson. And when the federal courts received that case in federal habeas review, they sent it back to the state courts for further proceedings so that he could get a fair review in state post-conviction. So the consequence of not having an attorney or adequate representation at that stage is you're going to see cases just ping-ponging back and forth between the state and federal courts. What we help ensure is that the process moves forward and you get fair, thorough, reliable review. The Resource Center represents most of the prisoners on death row in one capacity or another, either as direct representation or as co-counsel with volunteer law firms, that sort of thing. And we're a very small office. We do a lot with a little. We have 6 attorneys besides myself. Our salaries are the lowest of any public function attorney in the state by far. And we're not seeking parity, but the point is that we use our operating grant to do the core services that our office has to do, which is investigation of cases, including retaining, for example, experts who are very expensive, and doing literally the core services that we provide, which is what we're here to do. We operate out of the basement of a pizza restaurant in Inman Park. We operate in very Spartan.
You don't have to go far for lunch.
No. In fact, that's why we chose the basement. We make every dollar count. The reason that we are, I think, as you can see, we're requesting a grant increase, is because the Georgia Bar Foundation, which we had relied on for some significant funding over the past few years, has just been decimated by the economic downturn. And I think we're all aware of that. The reason it impacted the Georgia Bar Foundation funds was because they originate from the IOLTA, the aggregate interest that comes from the attorney escrow accounts, and a lot of that money came from transactions surrounding the purchase of property. Now that kind of tanked, and so the IOLTA fund went down significantly. So we have seen a huge decrease in what we're getting from the Georgia Bar Foundation. We can't, frankly, we don't know if we'll get anything for fiscal 12. The State Bar has the grants that we've received from the State Bar, again, were also emergency donations, so we can't count on that. The additional $234,000 compensates for the decline in those sources of funding, as well as we also bill the federal courts for work we do in federal habeas corpus, which goes into our operating money. That is also projected to go down. So this will compensate for that and bring us back to what used to be the baseline state grant level, which was about $800,000. For about 8 years, I think it was about $800,000. So that's what we're asking for and why we're asking for it. And I'd be happy to answer any questions you may have about our office.
Okay, before we start with questions, since we've got Mr. Davis standing up, let's go ahead and hear from Mr. Davis. And if you'll go to the podium, okay. I think that microphone's on. Check it. Yeah, okay.
Yes. First of all, Mr. Chairman and members of the committee, I want to thank all of you for your enhancement of $91,000 and some change for us for fiscal year 11. That is going to be extraordinarily helpful for us, and we're hopeful that the Senate, of course, will hold that, and we will ultimately receive the enhancement from FY11. I'm not going to tell you about our plight so much because you've heard about it. I think I was here about a week or two ago. You know we're an extraordinarily small agency. You know that our caseload continues to increase. I wish I could tell you that things have changed in the last 2 weeks, but they haven't. What changed in the last 2 weeks is we had another judicial resignation, and we filed a proceeding in the Supreme Court against a judge up in Northwest Georgia. So that is what has changed in the last 2 weeks. We are continuing to do the work of the commission. Our 7-member commission, all volunteer, continues to meet every month. I'll tell you, our meetings used to end around 2 or 3 o'clock. In the last 4 months, they go into the dinner hour. We are spending an extraordinary amount of time and resources to investigate the cases we have. We're going to have this year a 400% increase in the caseload. That is, we're going to have about, last year we had 33 cases that we docketed before the commission. Those are the cases that that we have to investigate and prosecute and resolve. This year we're going to, we've already hit the 65 mark. Going forward, we're going to have over 120. So you can do the math and you can see we're going to have over 4 times the number of cases this year in the hopper that we have to resolve with the same budget, the same staff, the same investigator, and the same resources. We are trying extraordinarily well, like the rest of the judiciary, to give you the most bang for the buck and to fulfill our constitutional mandate. But the reality is, if we don't do this job, the entire judiciary, the public confidence in the entire judiciary is going to be affected. So we're here today really to ask you. We had made a request. Before my tenure started on September 1st, we had made a request with our FY11 enhancement for $50,000. That is not going to get it. We're going to need at least $150,000 for FY12 to do what we need to do. Or we're just going to have to keep coming up here and asking you for money. And I would rather be spending time back at my office right now doing what I need to be doing, which is investigating and prosecuting judges. Because if I'm here, that means the JQC is not particularly active, except in the sense that our investigator is out there doing his work. So that's what we have. It's a crisis.
All right, we're going to take questions from the committee, and we're going to go in reverse order. So we will hear questions regarding JQC, then the Resource Center, and then the Judicial Council. Okay. So questions for JQC. Chairman Willard.
Thank you, Mr. Chairman, and welcome, Mr. Davis. I wanted to talk to you a little bit more about something you brought up, I think, last time you came to the committee, and that is the backlog you have of pending complaints that have been filed. What is your backlog number as of today?
Well, last time I was here, I said we had 3 cases that needed to be filed. One of those resulted in a resignation and is resolved. One of them was filed last week.
I mean your review of complaints. People file a letter saying, I feel the judge did something wrong. Those are the ones I'm talking about.
The ones, we're going to have over 600 complaints this year, up from about 487 from last year. I try to get complaints out the door within 30 days of receipt. I review every complaint, every piece of paper, and I'm the only lawyer in the office that does
That's my point. Are you able, in your sole role as the director and the attorney in the office to do the review, are you able to perform that function with the needed level of response time?
I would like to do it quicker. I'm taking this work home on the weekends. I do a lot of it at night. I work usually 2 hours a night reviewing the complaints. So I'm trying to do it and get the complaints out as efficiently, as quickly as possible, but it's becoming very difficult.
You and I have had some discussions. You probably talked to others, but I see the need that you have because you're the administrator of the office. You're the one that has to do the preparation of these cases as a means of getting them to this level of prosecution when necessary. But there's this backlog. How many backlog cases are you in need of reviewing at this time?
There are probably 50 to 70 cases right now that are sitting in a stack that I need to get to, that I just can't get to.
Mr. Chairman, I think one of the needs, I know we've helped open up, the district attorneys and prosecuting attorneys of the state have helped come forward and volunteering to give you assistance in the prosecution of these cases. So as I call it, we've opened up the pipeline at the end. It's the pipeline at the beginning that is now the choking part of it. Is that correct?
That is true. I mean, we're still having to prioritize our cases coming out because we still have expenses of litigation. Of course, the district attorneys are serving without any compensation,
right.
And we will have. My estimate is we will have expenses on the trial that we will have in Northwest Georgia of about $10,000 in court reporter costs, witness fees, putting our commission up. Our commissioners do not all reside in the Atlanta area, so we're having to still, Representative Willard, we're having to still prioritize our cases going out as we file them because we don't have sufficient funds to pay for the cost of prosecution.
If you had a need to fill, what would be that need with your budget?
If I had my wish list, I think what would be helpful for us is to have another lawyer on staff to be able to help us to review cases and to field ethics calls from judges and other types of things.
Do you need that as a permanent position, or would you be able to work a contractual position for the time being to alleviate this backlog you have? That's what I'm wondering. Which way are you looking at it?
I mean, obviously, if the trend continues unabated, as it has, I think that ultimately that position would become permanent, but I think you would make that decision as you move forward. Right now, with the cases that we have and the backlog we have, I think it could be a contract position, and then we could reassess it over time.
Wrap it up, Mr. Chairman. I think there's a crying need with this office because it's what Mr. Davis says. There's a confidence level that has to be maintained of the public with our judiciary that is, I think, waning because of this backlog we have, because these judges recognize the backlog that are under investigation and that the office itself is not capable of fulfilling its constitutional duty. That I hope the committee can somewhere find this contractual arrangement, whether through AOC or somewhere, law department, to give assistance for that need.
Thank you, Chairman Willard, and also thank you for your discussions with the Attorney General's office and trying to get some assistance for JQC going forward. I think Chairman Bearden has a question.
Thank you, Mr. Chairman. Mr. Davis, just as a reminder, because I know we discussed in the past, with 1,800 judges throughout the state, how many investigators you got to investigate the state and all the judges?
I have one, and he's also investigating teachers in the CRCT. So we have one investigator who gives of himself extraordinary time and effort, and Richard has been an incredible benefit to us, and he doesn't even submit his expenses, and probably only charges us for about half of what he does. But we have one investigator.
And over the last about 18 months or so, how many judges have we had resign or unprosecuted?
I think we're up to almost 30 now.
Well, I just want to say I appreciate the work y'all do and your conversation with us, trying to find other sources to make sure that y'all stay solvent and keep grinding. So thank you for everything y'all do.
Thank you, Representative Bearden.
If I'm not mistaken, has there been a bill drafted or a bill dropped to try to address some of the funding of JQC?
Yes. Yeah, there is one out there.
Would you describe for us a little bit about how it proposes to fund JQC going forward, and what kind of, if you know, the amount of money it intends to raise?
We looked at several different issues, and one of the ones we came up with was adding an additional 1% qualifying fee to all judges when they qualify for office. That should bring in additional minimum $150,000, maybe up to $225,000 per year that could go to the JQC. Of course, it's not designated; it have to go to general fund and appropriated in that process. But probably a minimum of $150,000 extra per year for the.
Okay. Anything else, Chairman Beard?
Just glad to see you today.
Any other questions? Mr. Representative Weldon.
Thank you for being here. Appreciate what you do, and I know it's a very difficult job. Could you just tell us what the backlog that you addressed earlier, is that, can you tell us what the dispersion between Superior Court, Magistrate Court, Probate Court?
I can give you the statistics from last year and say that at this point I would say that they're very similar. About 40% of the complaints we receive are from on Superior Court judges, and the reason for that is because Superior Court judges handle divorces and they handle felonies. And generally speaking, those tend to be some of the most contentious litigation. So Superior Court judges are about 41%. Magistrate judges are about 19%. The rest of I think state court judges are around 3%. Municipal, maybe 5 or 6%, somewhere in that range. It's in our annual report, which you can actually get off of our website. But the statistics are remaining about the same in terms of the class of judge that we're getting complaints about. Now, of course, a lot of the complaints that we get, we ultimately dismiss because they're complaints about rulings, and we're not an appellate court. A lot of folks think that we're there to be the third line of appeal after they've gone through the process. They file their complaint with us because custody was awarded to the father versus the mother, or the child support wasn't sufficient, or someone was sentenced within the guidelines, but they thought the sentence was too harsh. Again, those are rulings and not something that we deal with, but we still have to read those complaints. And I read every word of every complaint, because sometimes what someone complains about is not necessarily what they think is a violation of the Code of Judicial Conduct. And so as I'm reading through it, I may find something in there in the last paragraph that's something we need to look into that might be a violation of the Code of Judicial Conduct. So I take great care to review every single complaint, knowing that someone has taken the time to file that complaint and send it to us. And those complaints need to be reviewed very carefully. And I make sure that I do that, and then I write a letter to every single complainant if I'm going to be dismissing the case, and I explain to them why. I try to personalize it with them. And with 600 or more complaints a year, that takes a lot of time and a lot of care to do that. But that's generally what we're seeing. But of this year, of the 600 plus complaints, about 120 of those will actually go before the commission.
Okay. And if I could, Mr. Chairman, one other
Sure.
question. It's just you and one investigator.
It's me and one investigator and an administrative assistant. And she answers the telephone, and when two people are calling in, I answer it. And so I generally answer the phone 5 or 10 times a day.
How many telephone lines you got going into that office?
3.
Does that include a fax line?
And that includes a fax line.
Wow. Thank you.
Any other questions for Mr. Davis? Thank you, sir.
Thank you.
Any questions for the Resource Center? Thank you very much. Any questions for Judicial Council? Chairman Willard.
Thank you, Mr. Chairman. Ms. Moore, you were present when I was talking earlier about the roles between your office and the district administrative offices. What is the interrelationship, and how better could that relationship function if you see anything that needs to be done?
Well, at this
You've been
point,
administrator too, have you not, in the past?
I have not been a district
No,
court
okay.
administrator, but I have been at the administrative office of the courts in the
Right.
past. Currently, we do provide fiscal services for them, and that is a long-standing thing. That means that all their assets are on our inventory, their payroll is done by us, their billings, their accounts receivable. I don't know if they have any, but we handle all their fiscal. In the past, we've had different relationships with them and their assistance with us on gathering information from courts. I think it's just as Mr. Jones said, they have different, their functions differ a little bit by district depending on the needs. Many of them do work with judges in other classes of court, and we do what we can to assist them. But, they work for the Superior Court judge, the administrative district judge, and who serves on our council. So I also work for that district judge, our staff does.
On the council, does each district have a Superior Court judge representative to the council?
Yes, sir.
Is that how they're set up? Okay.
Yes, sir.
Thank you.
Mm-hmm.
Representative Weldon.
Thank you, Mr. Chairman. In the 2012 request that you made, you asked for restoration of $99,324 for the to restore the cuts that were made in 2011 for legal services to victims of domestic violence.
Yes.
Can you tell us what specifically that would be spent on?
We anticipate that would provide services to about 250 more clients. And I also have a representative of one of the programs that is a recipient of that here if you want to ask some questions about how that works. We do a grant process. We have a committee of the Judicial Council that oversees it. So there is an evaluation tool to ensure that the program is doing what they said. We try to spread that money out around the state to the extent possible, and we feel that it has been a successful and very much needed program.
I'm just thinking, I go to court a lot when I'm back home, and I'm thinking about the services, the legal services that are provided. Is that the folks that go up there and file the temporary protective orders and
Helps
annual
with that whole process,
permanent?
yes.
And is that what this is going to pay for? Those folks?
Yes.
Okay. Are we having any participation with the counties
As far as funding that goes into that?
As far as funding for that, yes.
I do not believe so.
Okay. And so, and that's what that $99,324. That's what all that'd be going for, is to
Yes.
pay for those people's salaries, keep them on the.
Yes. It
Okay.
goes to pay for services, whether, yeah.
And those folks aren't attorneys, right?
Some are not, but the funding that goes to Georgia Legal Services, I believe those are all attorneys. And it also provides training to our judges and our advocates, those people who are actually providing the service.
Okay. And if I could, Mr. Chairman.
How many more?
Probably just a couple more.
One.
Thank you, sir. You lost some vacancies in 2010 and 11, and you've requested to fill those at $226,000. What is that? What vacancies do you want to fill?
We're primarily looking at a planning and evaluation officer and our data services manager. There are a number of initiatives that are going on. I don't want to harp on the fact that we are at levels of way back, because we aren't doing business the same way that we were doing back when we were at different levels. But we also have different initiatives now and different imperatives. And some of those go to things like assistance in the IT department. We have a number of people that depend on the administrative office of the courts, a number of courts out there, and a number of programs that depend on us for their IT needs. We have to be a 24/7 shop. An example of that, and I'm speaking to the data services manager right now, an example of that is last Sunday we had an outage. We get our internet service and IT service comes through GTA. We use them as our provider there. They had a service outage. We knew that because we had staff who were working and providing service. Also, some of our courts out there that come across our Citrix system and use that were immediately aware. There was a different problem for us than other state agencies, because for some reason GTA had erased the AOC from their list of programs that they provide service to. So
is that typical of them?
It is not typical. I do want to say that. But the point is that for almost 24 hours we were down because of that. And we had a number of courts, plus our AOC staff, that, I mean, we were very much shaken and taken aback by that. But the fact that we have people that are having to work on Sunday in order to keep going with the service that we provide is just one example. We need a data manager to keep our programs going. They work with our developers and those programs. In the areas that we are looking at and what our initiatives are, when you look at our accountability courts and our ADR programs and our private probation or misdemeanor probation, which is all going to be very key in our initiatives as we're going on forward with this evidence-based sentencing and our judicial reinvestment, we need to be able to provide numbers from the courts, the actual information that helps you all make the decisions that you need to do in that funding. And that is an area that our office has been hit very hard, and we need to replace that vacancy. It's really a critical need.
Your microphone's off. Are there any other questions? Couple. There's been some discussion this morning with the Court of Appeals and the Supreme Court regarding consolidation of payroll or accounts receivable through the AOC. Would you address that, please?
I'm going to turn this over to Randy Dennis, who is our financial.
Okay.
Thank you, Mr. Chairman. As you know, we're statutorily mandated to provide fiscal services for the entire judicial branch for those that want it. We have consolidated most, or streamlined, was probably a better term, most all functions that we do, except for there's 4 others out there that we do not provide fiscal services for, but the services are offered to them. We were tasked to meet with those courts to determine. This process started with the idea of streamlining the payroll process, and I think we can consistently say that it really makes no sense to separate payroll from the other fiscal functions. The way that we have program budget set up in the appropriations bill, in order for one office to process payroll and the other expenditures process in another office, it just doesn't make holistic sense. We also found that, as we heard in previous discussions today and other discussions before this committee, that the courts are completely strained with human capital, which I think this is why this idea came about. But it's our hope that we could provide those services at the level that they're accustomed to. I wouldn't say easily, but that we don't believe would be a significant cost, and this is a savings, and this is what I mean by that. Any duties that we take on for them would not necessarily save, let's say, for instance, the Court of Appeals, because, as we heard this morning, that's not the only thing that those personnel do. However, I think that there's a void there that would allow, if we did take those on, would free those personnel up to focus on court functions rather than focusing on fiscal matters. We did consider holistically, though, while there may not be direct savings in the judiciary's budget, we realize there's probably a lot of efficiencies that could be realized with the state accounting office, as well as the judiciary, the Department of Audits. And what I'm saying is, just the best example I can think of is the current appropriations bill that we're currently under. There's a proviso in there requiring one of the courts to go on the PeopleSoft system. They cannot just do that on their own. They have to depend on the executive branch, which houses the PeopleSoft system, to do that. And through discussions with them, in order to set up an entire business unit for that court is very labor intensive. Okay, they're not really able to do that during the current fiscal period. So basically what I'm saying is they're forced to be in non-compliance with that proviso of the appropriations bill. However, in discussing it with them, we could provide that for them if they chose to do that. I wouldn't say easily, but we could add a fund onto our existing records and bring them right in at minimum cost. Initially, there probably would be some increased costs, but in the long term, I think the efficiencies will be realized statewide, as with the House Budget Office, the Senate Budget Office, the audit process, the state accounting office systems. And I think if you talk to the state accounting office, they would agree with what I'm saying today.
Representative Weldon.
Do you think it's going to be any requirement for you to add employees?
In order to, we kind of divided it up between the appellate courts and the trial courts. In order for us to take on both appellate courts, we would probably have to add 1 employee. If we took on the trial courts, we would need 2 additional employees.
So 3?
Yes.
1 for the appellate courts, right?
Yes.
2 for...
Also, in our request now is an increase in PeopleSoft billings. We also need to understand that while Court of Appeals is not on PeopleSoft now, if they were to go on PeopleSoft, our PeopleSoft charges would increase. So these are some of the costs that we talked initially. There would be an additional cost in order to streamline these processes.
But that would be a cost coming to us. If you don't,
Yeah.
if we don't come together, it's going to be a cost coming to the Court of Appeals.
Yeah, we paying it anyway. We look at it, right?
Exactly.
Okay. So that's not going to be a new cost. That's just going to be something we're going to reallocate to your
Well, no,
agency.
it would be an additional cost because now they're not on PeopleSoft when they go
Yeah.
on. It would.
Okay. And so you're going to have 2 people for the Superior Court judges?
Yes.
What about magistrates and those guys?
We already do those.
Okay. That's right. Okay. Thank you.
Couple of questions. The one person that you're talking about that it would take to do both of the appellate courts, are you just talking about payroll, or are you talking about all financial functions?
All financial functions.
All right. Have you had discussions with the finance people at the Court of Appeals and the Supreme Court as far as what these financial functions are and what kind of transition, what kind of information you would need? Because, you know, they've said that there are lots of things besides just accounts payable and the payroll that they do in those fiscal offices.
Generally speaking, we've received information from the courts on holistically what they do. The level of detail required to get an understanding of everything, we have time constraints on doing that. We understand how things are processed. Each court has certain requirements that's specific to those courts. That's why we feel that the personnel that's there now would probably have to remain in place and do some other things in order to provide the same level of service as they're accustomed to now. Whereas there's a lot of things that, say for instance, the Court of Appeals does for their judges and their clerks and their office and the way that things run to them, but the Supreme Court does.
I think if you think about the programs that we're handling now, such as the Council of Juvenile Court Judges or the Institute of Continuing Judicial Education, they have people within their offices that approve, work on budgets, collect, well, for ICJE particularly, they are collecting checks and payments for training now that they haven't in the past. So they have a person within their agency. Then what we do is we take care of the rest of it. We make sure that they're meeting their budget, that they're things are getting paid in a timely way, judges are getting reimbursed. Where the few things that we do still reimburse, but that's that would be the same thing that would happen with Court of Appeals, Supreme Court. They would still have to have personnel within their office to do those functions, and that's really what our argument is.
So have you taken enough of a look at this? If there are 4 people in the Court of Appeals who are in their financial office, and there's 1 in the Supreme Court, what, 3? 3 in the Court of Appeals and 1 in the Supreme Court. So we've got a total of 4 positions. And we're talking about adding 1 for you, and we are not talking about cutting any. What are we getting out of this?
Well, but the other thing is when we're talking about streamlining all financial services, some of the things that we can't do. We can't determine what's requested in their budget. They still have to exercise oversight in carrying out their budgets. We can't approve their expenditures. We can't. There's a lot of things that we absolutely can't do for these courts. They are still in control of their budgets, absolutely. What we can do is there's certain offices that may only have 1 fiscal person, and one of the things that should really concern us is that there's absolutely no way that they can provide for adequate internal controls and safeguard the assets with
And
this
that would be a
purpose,
benefit from this.
That's an added benefit. While there's absolutely no direct cost savings to a judicial branch budget, dollar for dollar, we think statewide with the efficiencies that the state accounting office would have with the Department of Audits, some of the things that they would have, as well as the budget offices, that the cost savings would probably be realized by those offices and not necessarily in the judiciary.
Less tax on those.
All right, the PeopleSoft Court of Appeals is currently not on PeopleSoft, correct?
We're on HR, but not financial.
Okay. The migration to PeopleSoft would, if they did it on their own, it would require a new license. If they do it through AOC, does that require a new license?
No, what it would require, if they did it on their own, the state accounting office has to go in there and set up an entire business unit. Whereas if we took that on and streamlined that for them, we would simply have to set a fund up within our business unit, which is much less complex than establishing a business unit on the system.
Talk to us a little bit about the drug court program. The governor is very, very interested in this, and I think that the legislature is very, very much interested in this. Tell us about how the funds are granted, how it's allocated among the counties, just a little bit about how that works.
Right, and I think Judge Bagley is here, and Edwin is here. Okay. Edwin's here. He can talk to you that. But I want to say, first off, that we have a nationally recognized program. We do an annual conference that is for training our drug court coordinators and judges and those that are involved in it. We do that primarily through a federal grant that we've been able to get. But we have a complete granting process. We have 10 core issues that each drug court that is coming to us for funds must meet, and we have an evaluation process that we follow up with on that. It's also the way we do the funding is whatever is granted in that first year, then we do a drop down. So we are not able to keep these courts on the state funding as we're moving out. As you know, you're probably aware, there's also some legislation that has to do with mental health courts. We have a task force that is looking at domestic violence courts, and that is also a grant fund that we have that's looking at those. And we also have 2 veterans courts that have received funding. So I'll just give that as an overview and let Edwin add to.
Good morning. Did anyone have any particular questions that they'd like to have answered? I'll do the best I can to answer those questions.
We're talking about drug courts. Representative Weldon.
You're a drug court judge?
No. I am one of the program development managers at the AOC.
Okay. How many drug courts we have throughout the state right now?
Around about 78. And when I say 78, I'm not just including the felony level superior court drug courts. I'm including the state court DUI drug courts, the juvenile drug courts, the family dependency drug treatment courts, as well as the handful of mental health courts that we have that may also have where those offenders who are in or participants who are in those programs may also have co-occurring disorders.
Okay, among those courts you just mentioned, which ones are processing or handling the most cases?
It varies. I could easily say the adult felony drug courts at the Superior Court level. But it varies from court to court and from region to region of the state. It's a bit hard for me just to, without looking at each court specifically, to give you a specific number as to who's handling how many cases.
So it's your belief that the felony drug courts that are handled through Superior Court judges are handling the most cases?
Probably about half of the cases, active cases.
And are you familiar with the statistics on success for getting people, the diminished recidivism rates from those drug courts?
Yes, I am.
Can you tell us what those are?
It varies
just in Superior, just Superior felony courts.
Anywhere from over a 3-year period, probably less than 20%.
That we're having in recidivists?
Yes.
Okay. Okay. I think we've got information from corrections on other things, so
okay.
I think that makes some sense to me.
Any other questions? Thank you all. Pack. You going to kick it off?
Yes, sir. I was waiting for the look.
All right.
Mr. Chairman, again, I'm David Miller. I'm the DA from Moultrie and the budget chairman of the PAC this year. I've got Stan Gunner, our new deputy director, and Michael Parkinson, who's our new budget analyst with us. Looking at this rocky road of the budget that we're on, before we talk about going down the road, let me take just a minute to talk about where we've been. Y'all know that at the PAC, the staff itself, we've gone from 49 positions down to 33 positions. That's a 33% cut in the positions of the PAC. In the district attorney's offices, of course, in the continuation budget, and I'm assuming for purposes of this budget, y'all are eliminating our 16 state-paid victim advocates. That's, of course, 100% of the state-funded victim advocates and would account for $800,000 in this budget submission. And just yesterday, I think we got the word from the State Bar that with the combination of reducing our square footage in the State Bar building, so we don't need as much space because we don't have as many people, and them reducing the rent to the State Bar, that's going to be a savings of $189,276 out of next year's budget. In our budget submission, we did ask for some enhancements. And the first thing I want to say is that whenever I'm dealing with somebody in a position of authority like legislators, county commissioners, or my wife, if I make a mistake...
Or Superior Court judges.
Judges, certainly. If I make a mistake, I think it's the best thing to do to admit your mistake, explain your mistake, and move on. I want to tell you that at 8.2.4, we made a mistake in asking for the funding for those 3 ADAs that were associated with the 3 new judgeships. We did not think those had been included in our budget. After talking with Kendra and meeting with Lauren, and after Michael came on board to help us, we realized that, in fact, those 3 ADA positions had already been in our base. So that money, that $235,522, certainly you can take that money out too, because that was a mistake on our part.
We'll be happy to.
I'm trying to make your morning here, Mr. Chairman, in addition to being last on the agenda. At 8.2.3, that money, again, was a mistake because at the time that we asked for those 2 positions were the 2 vacant victim advocate positions. We had frozen the victim advocate positions and not letting people refill those when they left. Of course, again, those would have been included in our base. We just knew that we didn't have the money to pay them, so we had asked for the money for that.
So which one is that?
That's 8.2.3. That was 2 victim advocate positions. Let me say that in recognition of the fact that y'all have eliminated the 16 state-funded victim advocates, if you could see your way to move $60,000 of that dollar out of the DA's budget and put it into the PAC's budget, what we would really like to do is have a position on staff at the PAC as a victim services coordinator. That was the position that Christy had at our office before she went to work for Speaker Ralston. Y'all had funded that in years past, but then it was vetoed in the governor's budget. So we don't have funding for a state-funded victim services coordinator at PAC. You'll remember that even though you've eliminated the state-funded victim advocates, we've still got victim advocates out in the DA's offices funded with the VOCA grants, the 5% money, and local funding. It would be extremely helpful to us to have a resource at the PAC dedicated to those victim advocates out in the state who can help them with their VOCA grant applications, which are becoming more and more competitive, and help us with training issues with the victim advocates, because we've still got them in our offices. They're just not state-funded anymore. So we think that would be an appropriate position to have at the PAC. At 8.2.2, that money is for promotions for the assistant district attorneys that were approved by the individual district attorneys in 2009. And then when the budget woes hit, we just didn't have the money to pay them. So we have not paid for those promotions that had been approved by the district attorneys. And that's why we keep asking for that $349,000 because some people feel that we have a legal liability there for those assistant DA promotions that were approved but have never been funded. And then, of course, the main thing I want to talk about is 8.2.1, to provide funds for the budgetary shortfall. The purpose of this is to try to get out of furloughs going into our 4th year. We have had 3 years of furloughs. We have furloughed a total of 24 days of our people. And I know y'all have heard from folks this morning talking about how their people go above and beyond. And Mr. Chairman, you asked were any senior judges volunteering any of their time. I just want to give you to personalize it, give you an example of the quality of people we got working on our staff. When we took our first furlough day back in FY 2009, I think we took our first furlough day in August. We had a homicide in Valdosta, and the information was the body had been dumped in a pond over in one part of town. The Wakulla County, Florida Sheriff's Department has a submersible video camera that they get out in a little John boat with that submersible camera, and it can map the bottom of a pond. And so they were coming up to look for this other recent homicide. Well, at the same time, several years earlier, we had a young mother in her early 20s with her 4-year-old child who had gone missing and who we were convinced had been murdered. They were both on medication, no records anywhere in the country of any of these necessary medications being refilled. There were 2 or 3 good suspects, but we were not able to make a case. We had not found the bodies at that point in time. And while Wakulla County was up there with their submersible submarine, we asked them, well, when y'all get through the Valdosta Police Department, will you come over here in the woods behind this apartment complex and map this pond for us? This is the apartment where she went missing from, to see if by chance there are any skeletons or any of her property down there in that pond. And they said, well, sure. We just got to have a path wide enough for us to get in there with our John boat and our submersible camera. Well, it was extremely thick overgrowth. There were no paths around this because it was just an old retention pond or something. I don't understand why there weren't any paths to where you could back up to a vehicle and get to the pond. On our first furlough day, and we were told that we can't come to work on our furlough day because we can't volunteer and come to work because it would be a violation of federal law. So let me make it clear. On our first furlough day, voluntarily, myself, my state-paid investigator, and 2 of my state-paid assistant DAs, instead of going off to the beach or fishing or spending time with our family, in the heat and humidity of August, we took sling blades and bush axes, and we went down there and we cleared a path about a quarter of a mile to get to this pond so the guys from Wakulla County could come in and map it. They came in and mapped that pond. Unfortunately, nothing came of it. But I just want to personalize for you the type of people that we're talking about that we're furloughing out here in the field. 24 furlough days, there are only about 21 or 22 work days in a month that you're paid for. So those 24 furlough days, our people have written like personal checks to the state of Georgia for over a month's pay, each one of them. So we would like to end the furloughs going into fiscal year 2012, and that's why we're asking for that $1.1 million. I would say again that if you're taking out the $800,000 for victim advocates, the $235,552 for the 3 ADAs that we mistakenly put in there, and the $189,276 that you'll be saving on our rent next year, that's $1,224,828 that you're already taking out of our budget. We'd ask for you to look at that $1.1 million and see if y'all can do something to help us stop these furloughs. And with that, between the three of us, maybe we can answer any questions you got.
Are there questions?
I think Chairman Willard, I read his lips before he left, and he said, "Give the DAs whatever they need to get by."
He didn't leave. He didn't leave that list with us.
I could see his lips moving from where I was.
I'm going to ask Kendra on the one position that they asked for. Did you make note of that?
The one position
At PAC, isn't that right?
Yes,
yes,
we would
I
ask
did,
to
yeah.
move 8.2.3,
services.
just 60,000 of that over to the PAC
Yeah, just to
budget.
transfer the money. Yeah, I made note of that.
Okay. All right. And are there any other questions? Thank you all very much.
Thank you, sir.
All right, have we got the Public Safety Training Center, Gypstick? Is that next? You're standing between us and lunch.
No, I'm trying to get up there as quick as I can. This is a bad position to be in. And I do want to thank you for letting us come early. And especially thanks to Kendra. She worked with us, got us here. And what I'd like to do is just do, on your sheet, I think it's 38.12.8. We're going to replace state funds with coroner funds and federal funds to about $71,994 worth. Reducing funds for replacement ammunition and repairs and maintenance is $53,000. I think that's your 38.12.7. The 38.12.6, charging tuition to students who fail the class, we've got down for, we went back and figured it's about $32,500. That money won't ever show up because when the sheriff or the chief has somebody fail, they may send somebody else, but they ain't going to send that one back. We won't see them again. The elimination of the library position, 38.12.5 is $60,931. And our plans right now is to actually close the library, convert that space into meeting space, and not have a library. The savings from attrition and elimination of 5 vacant positions is $277,153, and that's your line 38.12.9. That's actually 3 of these are admin positions, administrative assistant positions. We'll just have to get rid of them. Some of these have people in them, some of them don't. And the consolidation of course programs, $294,860, is consolidating and eliminating the North Central Police Academy contract, which is up in Austell. They actually run 2 academies in Cobb County. One's Cobb County PD's Academy, the other one is the North Central Academy in Austell. For years, we have supplemented their budget by giving them money. We don't actually control their operation. We figure it based upon the number of heads they send through, and we figure that's an avoidance for the rest of the system for them to train them. We're talking about eliminating $205,000 from them. And the second part of that is closing the Augusta Academy. If you look at the numbers, the Augusta Academy has fewer officers that go through there than any other academy that we have in the state. And we're actually in dealings with Sheriff Ronnie Strength and Clay Whittle, the Sheriff of Columbia County. I think they have a lot of interest in taking over the buildings that we have. There's 3 double wides there, which are basically, you know, what the school system uses for modular classrooms. We don't own the land. We own those 3 trailers. They're interested in probably at the end of this calendar year looking at taking over that operation and running their own academy, because about out of the numbers that we trained last year and the year before, the only two real ones, there were 79 students total. Richmond County had 20 of those students, and Columbia County had 11. So if you add those together, the biggest user of that academy is actually Columbia County and Richmond County. And I have talked to Ken Vance, the director of Post. There's no problem with them having an academy there of their own, which helps personalize that basic training effort that they want to do.
Chairman Bearden.
Thank you, Mr. Chairman. When they built the Allen Powell Corrections Facility there at Tift, was there no savings? Because I believe I heard, if I'm not correct, Representative Powell, that there could be some savings to Gypsy by them doing that.
Not really, Mr. Chairman, because what we ended up doing was actually they transferred their operation over there. We were charging them for meals. We were charging them for some other things, but it was a direct operating cost that they're still doing that. We didn't save any money by them leaving. We did gain some space. We built the training center for an average daily population of about 500. We had got into the 12 to 1,300 a day, because corrections have 300 there for a basic correctional officer training class. So we actually have gained back about where we should have been. We have 700 or 800 a day now instead of 12 or 1,300.
So we can safely say there wasn't about $17 million in savings by them doing that then.
We haven't seen it. We haven't seen it. If it's there, I sure would like to have it.
Is there a increase or decrease in the students coming down to Gypsy now?
There's a decrease in the number of students, not dramatic. We've seen probably a 30% decrease. Number one, because agencies have the same problem the state does, is they're all cutting their budgets. So even though we don't charge tuition to certified officers, peace officers, firefighters, EMT officers, and so forth, we don't charge them tuition. They still have $3 a gallon gas to get there, and they still have to pay for their meals, because 2 years ago we gave y'all back about $1.3 million for the meals we were providing.
Yeah, some of those decreases been from some of the technical college programs that's out there.
Well, you know, there's 6 pilot projects with the technical schools doing basic training. They generated last year less than 150 students for the whole year. We generated almost 1,500. So the numbers are small still. Most of them are doing 2 classes a year, where my regional academy is doing 8 classes a year that are slap full. So, I mean, there's very little impact on us. We hope that in about 5 or 10 years, there will be a pre-service academy system that takes all this away from us, but it's not there yet.
How far away is it?
I'd say it's probably at least 5 years or so. Our customers have been used to 40 years worth of they go hire somebody and they send us to be trained. We're trying to work with Post and the technical schools and everybody else to turn this around so that there's a day coming where if you want to be an EMT, you go get your training, then you go get a job. You want to be a lawyer.
Just like everybody else does.
Yeah, just like everybody else. But it's slow to come to the helm. I mean, we've turned the wheel as far as we can. We still have a lot of chiefs and sheriffs who don't see it that way. They want to do what they've been doing. They want to do a great background. They want to send us folks. We train them and send them back home. Now, the danger in that has always been, and I've been candid with them, you're sending me somebody that may not pass driver training, may not pass the testing in the written test, and may not pass firearms. We have an attrition of about 30% of the folks that we start in basic training. We graduate about 70%.
And the other aspect of it is then it either migrates to somebody else's pocketbook or it migrates to Hope if they're Hope qualified and they go through the technical schools. And as I understand the technical school program, the added benefit is that some of those hours actually qualify as college hours.
They can when they start in the program. I think they have to actually declare whether they want to do that. They have to actually enroll in the technical school as students for a certificate program, and some of them actually offer up to a 2-year degree. I mean, you got to go to more to do that, but that's a blessing and a curse, because most of the tech school programs are 20 weeks long for basic training to fit in that box that we've talked about getting that credit for college. Our programs run about 10 weeks and 3 days. It's a 408-hour curriculum. again, it's a blessing and a curse. Yeah, you're going to give them some college credit, but yeah, they're going to be gone longer. If it's all pre-service, that doesn't matter to the agency. Some agencies are actually hiring people and sending them to the tech schools. Well, you lose them for twice as long if you send them to the tech schools.
And then my final question is the academies that you're closing. You know, I asked you for some information about the cost shifting aspect of that.
Absolutely.
Would you tell us what you came up with on that?
And the cost to Richmond County, now we figured it with 3 different options. If they send them to an academy, for example, the closest one, let's say they send them to Athens, which is reasonably close, Richmond County will have a cost of $96,496. But that's with them paying for a motel, meals, and transportation. If they send them to the training center, and we're assuming this is a year-long we looked at, it's $28,699. Closing of those academies does shift, there's no way around it, that does shift some of the burden to the local agency. At the training center, for example, we used bond money 25 years ago to build dorms. I'm not going to charge basic students, I'm not going to charge Ronnie Strength, the sheriff in Richmond County, any money for his student to stay in the dorm. They're going to stay in the dorm free. Now, if he sends them to Athens or to Savannah, to Garden City, he's going to be paying whatever the state rate is. We figured on state rate for $60 a day for lodging. So, and I make that available to them, and I tell every chief and sheriff, you send them to us, they stay at the training center because we've already paid that bond money back to build those dorms. You stay with us, I'm not going to charge you a penny. Now, they still have to pay for meals, but the meals at the training center, number one, are good. You can tell by me, they're good meals. And the second thing is, it's cheaper than you can do on the local economy. You can send them there for $18 a day. They can eat like kings 3 meals a day. So we're trying to make some reasonable alternatives and yet fit within the deletions that we have to come up with.
Well, and you understand that the crux of my question was to look at the total cost, not just the savings to the state, because if the savings to the state was at a certain level, but it wound up shifting more than that to the local government, then it wasn't really a savings.
Absolutely.
But your analysis is that they're, especially if they send them to the training center, that there's still a savings.
There still is.
Okay.
Yes, sir.
That was the information, and if you will share that with Kendra so that she can put that in her file so we can answer questions if there are any.
Sure.
Any other questions? Thank you very much.
Thank you again. Appreciate it.
Any other business to come before the committee? Monday. All right, we are adjourned.